16.
You
In account
file
16. Yes.
A we can, will come up on some other.
May I please, Lordship? Not pressing for item number 4.
Wait, you want the IA to be lifted next week?
16 is there. Here, what we filed a IA yesterday.
I understood, the IA has to be lifted separate.
Then of it, tomorrow put the case.
Then I can very well direct this matter to be adjourned, to be listed on day after, on Monday, not with the IA.
Not.
We come to the hearing on behalf of
DRTO. DRTO.
DRDO. Submit that and interlocutory application has been filed in deputy number 482 of 2019. And he may be permitted and the instant petition be listed and put the date interlocutory application. The registry shall register the interlocutory application is the same along with the petition number 482 of 2019 with the instant petition on Monday date.
Much of. May I please, Lordship? I am not pressing item number 4.
Your name?
Mr. D.P. Mandal.
Mr. D.P. Mandal, the learned counsel appearing on behalf of the petitioner, submits the petition. He has instructions to withdraw the instant as petition, taking into account the above the state petition withdrawal. Maintaining orders if any stand very regular there.
Wait, Mr. Lord. I beg to mention in regard to item number 21, if we are taking the position of the other side. And the adjourn the matter for after vacation.
Council appearing on behalf of the respondent, but 3 and 4 submits that some time may be granted and the matter may be adjourned today, taking into account above this matter on 7th of September 2020.
May it be please, Lordship? I beg to mention for item number 29. Yesterday, IA has been filed. Lordship may kindly call for.
What is the urgency? You are for the petitioner.
Yes, we are a petitioner. Appearing on behalf of M. Dotto. I am appearing on behalf of M. Dotto.
I first order to not Monday. We'll have it after vacation. The vacation of later the day. Put on it. 17.
May it please, Your Lordship, I beg to mention item number 30. Can you adjourn the matter for today and list the matter after vacation? My lord.
Personal appearance. Item number 13.
No, item number 30.
What do you want?
Can you adjourn the matter for today?
Taking the consent from the other side.
Your Lord.
Next. No. Sorry,
I was just instructed according to my.
can't help you. Next.
May it please, Your Lordship. Your Lordship, I beg to mention item number 2, Your Lordship. Item number 2, Your Lordship.
2.
Yes.
What do you want?
Yes, Your Lordship, as per the last order,
When
we
the
have,
matter is there or it is come up for order, we'll take it up when the matter is. Wait.
Wait, please, Your Lordship, in last occasions, our names were not shown in the cause list. That is why you missed it, Lord. And Lordship was pleased to pass an order directing the either the council or the person concerned to be appeared. Well, in this case, substantially the order is complied with. The only thing remaining that the remaining amount that we are supposed to pay, we propose to pay per month, 2 lakhs rupees in 12 months.
I've seen the affidavit,
Mine.
but on that day I could not pass the order on the ground that nobody was absent.
Yes, but I apologize.
Either the contender will be present or by to a council.
My lord, I apologize, my
Lord.
lord, because
My lord, I have only one thing to say, my lord. Paragraph 3 of their affidavit, my lord. 2 lakhs we have received out of what they admitted amount, my lord, of 25,80,000. And thereafter, my lord, this last line, the remaining amounts will be paid in installment within 1 year from now. My lord, we want a specific data.
No, don't worry.
Yes. Because
It is an undertaking given by him. We'll incorporate it and say that the payment today is what?
today
today
is,
is 17th of June.
17th of, by 16th of June 2027, the entire amount will be liquidated.
My humble prayer, my lord, can it be like a per month? Because when we have a talk with them, the 2 lakhs per month they agreed to pay. That may be on record, my lord. That will suffice, my lord.
And remaining shall be paid in installment within 1 year.
Yes.
How much is remaining?
23 lakhs 80,000. So 2 lakhs
If
per
the
month.
remaining amount of 20 lakhs is paid in installment. The
23 lakhs.
petitioner already executed consent in that regard. Following the arrangement that you have paid 2 lakhs. Now remaining is how much?
23 lakhs,
23 lakhs 80,000.
18 lakhs.
23 lakhs
23.
80,000.
23 lakhs.
23
Kindly
lakhs.
see paragraph 17.
My lord, in paragraph 2, it is 50 lakh 80,000 admitted amount. Out of that 25
5 lakhs payment. And after
27
that,
paid.
25
Why
lakhs. were
he is
paid.
mentioning 20 lakhs at paragraph 3?
yes, it is wrong, but a typographical mistake.
It should be 23 lakhs.
23 lakhs.
23 lakh.
Because-
80,000.
Yes.
Okay.
Because 2 lakhs we have paid already.
We close it by giving every month lakhs.
Yes.
And the last month
1 lakh 80.
has to be paid as 1,80,000 free.
Man,
Deep
you should
shop.
Wait. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. A. Samwa appears on behalf of the contender. Gustav. The instant application had been filed by the petitioner alleging willful and deliberate violation to the order dated 4/6/2025, passed in WPC number. Which one? WPC number?
Page 8, my lord, WPC number 2197 of 2017.
Only one. 2197 of 2017.
Page 8.
Wherein there was a specific direction to make payment to the petitioner. After carrying out the verification within a period of 5 months from the date of receipt of the certified copy of the order. Custom. On account of non-payment, the petitioner had approached this court by filing the instant application alleging willful and deliberate violation. This court duly takes note of an affidavit filed by the respondent by the sole respondent, that is the managing director of the ASTC, by the sole respondent, that is Sri Chinmoy Prakash Bukon, the managing director of the ASTC. In the said affidavit, it is mentioned that after carrying out the verification, it was found that the petitioner was entitled to an amount of 50,80,309, of which an amount of 25 lakhs have already been paid. It is also mentioned that in addition to that, another amount of 2 lakhs have been paid.
Yes.
The remaining amount to be paid is rupees 23 lakhs 80,309, and an undertaking has been given at paragraph number 3 of the said affidavit by the contender that the said amount will be paid within a period of 1 year. This court duly takes note of the submission of Mr. A. Samwa, the learned counsel appearing on behalf of the respondent, to the effect that there is a typographical error in paragraph number 3 wherein it is mentioned that the remaining amount payable is 20,80,309, which ought to have been rupees 23,80,309. Taking into account the same, this court directs the respondent to make payment to directs the respondent to take effective to comply with the undertaking so given before this court and as agreed to the payment of the remaining amount of rupees 23,80,809 is directed to be paid within a period of 1 year from the date of the present order. It has been also agreed to that every month from today, that an amount of rupees 2 lakhs would be paid, and for the last month, an amount of rupees 1,80,000 would be paid. 1,80,309 paid. The agreed installment basis is given herein under. Alikitai, June, July by 17th of July. Yeah, start from what I think. 17th of July 2026 or not before 17th of July 2026. One, 12, next given amount we paid on it before. Next before the date or not before the amount to be paid or not before. That's the date first to the one, number 2 letters. Or not before 17/7/2026. Next is the last of 12 to 1,80,059. On or before 7/16/2027. It is observed that if there is a violation to the above directions, it would be construed to be a violation. It would be construed to be a violation to the directions, not only to the directions passed by this court in the order dated passed in WPC number so and so, but also would be construed as an violation to the undertaking given before this court. The instant proceedings accordingly stands closed.
Obliged.
Yes, why this matter is for me?
Lordship, the affidavit that I'm supposed to file, it's in the process of filing today itself.
Why are we filing a affidavit when the person is not what are you challenging?
Your Lordship, I am challenging the summary so-called notice and the summary order, Your Lordship.
Why?
Because Your Lordship, summary so-called notice, it has to be, ought to have been given notice under section 73(1), Your Lordship. But it is given under the rule 142.
Oh.
The requirement, Your Lordship, the law is there. Your Lordship has passed a judgment, Your Lordship. So,
Summary so-called notice has to be given, how?
Your Lordship, notice has to be issued on 73(1).
This will be issued under
75(1).
But how do you do it? It is to be in terms of rule 142(1)(a).
Your Lordship.
The summary is 142(1)(b).
Your Lordship.
And the form, it has to be in DRC 01 and the other has to be in DRC 02.
Your Lordship.
Then
Attachment is
what is
DRC 2. Your Lordship, but Your Lordship, the law is there, Lordship. Your Lordship has passed it.
but
Your Lordship has passed it.
show me where.
Your
What is the case? Why is the matter so big? Let's see your proposal. Necessary we set aside at the motion stage itself. Where, what is wrong? They have not issued the so called.
No, no, Your Honor.
We set aside giving you the liberty to. Because the time is running.
Yes, yes, ma'am. That's right.
Keeping this matter pending doesn't make sense. Heard Mr. N. Ja. Double N or single N?
Your Lordship,
Are you double N or single N?
NN, Your Lordship. Nityanand Jha, Your Lordship. Nityanand Singhal.
Heard Mr. N. N. Ja, the village council appearing on behalf of the Mr. Soil so appears on behalf
All
of the
the- all the-
Finance and Taxation Department of the government, representing the respondent numbers 1, 2, and 3. The present petition has been filed. Where is your so-called notice?
Your Lordship, page 24.
Date?
24, Your Lordship.
Present so-called notice, the present application has been filed. The order has been passed.
Your Lordship.
What?
Yes, Your Lord.
Then? You
Your,
are challenging an order in original
Your Lordship.
or an order in appeal.
Your Lordship, in original, Your Lordship.
Did you reply to the so-called notice?
Your Lordship, I have not replied, but I pray for reply, Your Lordship, they have played order passed.
Lordship, may kindly turn over to page 37. Lordship. There even he has opted for no personal hearing. Lordship.
I pray for time, Your Lordship.
Now, what is this page 26 is what?
Yes, ma'am.
Why haven't you filed an appeal?
Your Lordship, because Your Lordship, I have enacted the document, Your Lordship. My wife is suffering from illness, Your Lordship. And she is detected almost a cancer type, Your Lordship. I have filed the documents, Your Lordship. So this time has passes, Your Lordship.
Right. Who file an? Because if it comes to me,
Your Lordship.
I will give him the entire 10 from 2023. You understand that?
Your Lordship.
Would it be in your favor? If you can get this order set aside
Your Lordship.
before the appellate tribunal and appellate court,
Your Lordship.
appellate authority, then in that regard, he cannot issue a new peace law.
Your Lordship,
Because the period is as per 73(3)(10) is
3 years, Your Lordship. In fact, this is also the case here in Your Lordship.
that's good, it is 3 years.
Your Lordship.
Now, what has happened 3 years, it is so. If the order must have been passed in 2024 itself,
Your Lordship.
now, if this entire thing goes, then without taking my judgment in the case of construction containment,
Your Lordship.
we may have a good case. before
Your
the
Lordship.
tribunal. But if I am to pass an order, I will pass an order giving him the limitation that from 2000, this period from 8/3/2024 till date be excluded while completing the period for 73(10).
Your Lordship, regarding the limit, appeal
I
before,
will give them, I will give them the first period because you are asking this.
like, they may be given a liberty to issue so-called notice as usual, Your Lordship, because
I have to also give them the liberty as per this 8/3, this is the technical mistake.
let,
Kindly see, no, kindly see.
yes, it is here, Your Lordship. Observation is here, Your Lordship.
I given out the grants liberty to the respondent.
Yes, sir. Yes,
In your proceedings on the 17th for the relevant financial year. Further observes and directed a period from the date of issuance of the summary so-called notice. Upon the petitioner till the date the certified copy of the judgment is served upon him will exclude it while completing the period of limitation.
yes, their liberty is there, Your Lordship.
You want
Let,
that?
let him take the course of their liberty, Your Lordship.
I think that is a better. The present petition has been filed by the petitioner excelling the show cause notice dated 18/12/2023 issued by the respondent number 3, as well as also challenging the order in original dated 8/3/2024. Is it 8/3/2024?
24 Your Lordship.
Are you sure?
Your Lordship. Page 39.
Order in original dated 8/3/2024. The learned counsel appearing on behalf of the petitioner submitted that it is the requirement of law in terms with section 73(1) of the Assam State Assam Goods and Service Tax Act 2017 that there has to be a show cause notice. The summary of show cause notice is a separate aspect which section 73(1) of the Act of 2017 categorically mandates. The learned counsel appearing on behalf of the petitioner further submitted that Rule 142 1A categorically mentions about the show cause notice to be issued in Form DRC 01. In that regard, it is also the submission of the learned counsel appearing on behalf of the petitioner that merely issuing a summary of the show cause notice would not suffice to be a show cause notice within the meaning of section 73(1) of the Act of 2017. That regard, the learned counsel referred to the judgment of this court in the case of Construction Catalyzer Private Limited versus State of Assam and two others reported in reported in 2025 to GLR 85 and submits that the same issue have been duly dealt with. Mr. B. Chaudhary, the learned counsel appearing on behalf of the Finance and Taxation Department of the Government of Assam submits that the petitioner has an alternative remedy available under section 107 of the Act of 2017. He, however, duly submits that the issue involved in the instance proceedings is also covered by the judgment in the case of Construction Catalyzers Private Limited Supra. In addition to that, in the submission of the Standing Council of the Finance and Taxation Department of the Government of Assam, that as it is a technical mistake, the period of limitation which is otherwise prescribed under section 73(10) of the Act of 2017 to pass an order in terms with section 73(9) of the Act of 2017 be excluded from the date of issuance of the said so-called notice, so that appropriate orders can be passed. This court, having perused the materials and report, finds it relevant to take note of the Observations of this court. At paragraph number 20,
29 F2.
21, 22, 23, and 24 of the safe judgment in the case of construction catalyzers private limited. And it is the opinion of this court that the issue involved in the present proceeding is squarely covered by the same observations and opinion rendered in the case of construction catalyzers private limited. Accordingly, paragraph numbers 20 to 25, 24, being relevant are reproduced in under section of 8. This note also takes note of that in the case of construction catalyzers private limited, this court had not only set aside this court had set aside the orders in original past therein, but also granted liberty to the respondent authorities to initiate de novo proceedings under section 73 if deemed fit for the relevant financial year in question. Further to that, this court also observed and directed that the period from the date of issuance of the summary of the show cause notice till the date a certified copy of the instant judgment is served upon the proper officer be excluded while computing the period prescribed for passing of the order under section 73(10) of the Act of 2017. This aspect is available at paragraph number 27, 29 F, which is reproduced here in under 29. In that view of the matter, the instant petition stands disposed of with the following observations and directions. Oh, 1. The impugned order in original dated 8/3/2024, passed by the respondent number 3, is set aside and quashed. Number 2. This court is not setting aside the notice, the summary of the so-called notice which have been issued on 18/12/2023, which is annexure 2 to the petition. However, directs the respondent number 3, who is the proper officer, to issue a show cause notice in terms with section 73(1), detailing out the cause of action for initiation of the said proceedings under section 73 of the Act of 2017. The said show cause notice, for which liberty is granted, shall date back to the date of issuance of the summary of the show cause notice dated 18/12/2023. This court further observes and directs that the period from the date of issuance of the show cause summary of the show cause notice dated 18/12/2023. Till the date, a certified copy of the present order is served upon the respondent number 3 shall excluded while computing the period of limitation in terms with section 7310 of the Act of 2017 to pass an order in terms with section 73(9) of the Act of 2017. The above the instant proceedings.
In terms of liberty, they granted to us to reply to.
Obviously, that is why there is.
Now, one observation, you know, one observation.
Needless to mention that when a so-called notice is being issued, as per the liberty granted to the respondent number 3, the petitioner would always be at liberty to file the reply within the time stipulated in the date show. Have you filed a memo party?
Yes, Lordship.
When?
Today.
No, you have not filed. You have not filed it. This is the order. When did you file it? As per the Honorable Court order, the petitioner was directed to file fresh memo parties on 9/3. However, no fresh memo parties have been filed.
Lordship, we have filed them. Lordship.
When?
Today, your Lordship, maybe
What is this petition for? Okay. What is the case for? What are you? What are you telling me?
your Lordship.
What are you telling me?
Your Lordship, as per my senior's instruction, your Lordship,
Huh?
he has some personal difficulties, your Lordship.
What?
He has gone to attend his sister-in-law start ceremony, your Lordship. Senior counsel.
So,
Mr. Ikeburubushna.
and without his presence, you have filed the memo parties. You have filed it today. Sure. It has been submitted that the fresh memo parties have been filed today. It's taking into account the above list the matter for admission. We have no urgency. No urgency. You have not filed affidavit.
Some instruction has come.
List the matter for admission. Mr. Dinath, who appears on behalf of the respondent numbers.
Appearing for the number 2, 2, 3, 2, 3, 12.
2 and 3. And you? You are tribal affair. Now you are going to file reply? No. Okay. Mr. Dinath, who appears on behalf, why the respondent number 2 and 3? Here, what is the case?
They have prayed for ST certificate. The petitioner has prayed that he should be given an ST certificate. And there is a prayer one of that to all the villagers of a particular village, the ST certificate should be given.
That is too much.
That is too much. And as regard the claim of the petitioner, my instruction is ultimately the caste has to be determined by the state level scrutiny committee.
Absolutely.
The DC has to send the papers to the state level committee. As regard the claim of the petitioner that his father is having the ST certificate, my instruction is that in fact the organizations they have stated that he belongs to Ahom community and Robi title, but people in that particular village, some are having OBC certificate, some are having ST certificate. So there is a conflict. So he cannot claim that he should be entitled. So that he's entitled.
Anyway, that should have been decided by.
Yes, but
Anyway, do you want to file a?
I'll file the affidavit.
Appearing on behalf of the respondent number 2 and 3 submits that he would like to file an affidavit. This, taking into account that this petition is almost a decade old, it is a decade old matter, list this matter for final disposal on 17th of August 2026. In the meantime, the affidavit be filed on behalf of the respondent numbers 2 and 3 on or before 5th of August 2026. Liberty given to the petitioner to file reply now before the next. No representation.
Pass over for time being.
Huh?
Pass over for time being.
What is it? Why you are not appearing in this matter? Yes, Mr. Renath, what is the case?
The direction of the honorable court is to page number 12, Malad. The deputy commissioner has page 15 is relevant.
So during the Puja vacation, he called the petition. So you have not paid till now.
The amount has been calculated by the district commissioner and it has been sent to the PW department. The department has filed an affidavit in the petition. It is on record, but they said that some papers are required. The petitioner is to submit those papers. On last-
Papers means
The required documents kindly, we have
what papers?
kindly take the affidavit of the PWD.
Affidavit of?
It's filed by my learned friend. That's one number 10. Kindly come to page 45 and C. Page 45 and C. This is the part of the affidavit of respondent number 10. On 30.
Death certificate of late so and so. Next of the keen legal aid certificate. Bank account of the petitioner. Letter of NOC to make payment through one petitioner. Then
Well, it was apprised to the honorable court on last occasion. My learned senior friend has submitted that these are already submitted to the authority.
yes,
So-
it is already there. I could see it from the reply. They have already submitted a reply out here. This is the death next of kin certificate at page 71. Who are the legal heirs? Then what do you want?
Well, if it is submitted, then the department has to process. My current friend, no, I'm not aware of that reply. No.
No, it cannot be. This is a very old matter. You cannot have it. And now who is going to pay the interest? Tell me, who is going to pay the interest? Is the officer, the PWD is going to, because after the reference court passes the award, there is an interest accumulating if the amount has gone higher as per 28. So who is going to pay that amount? Is it to be paid by this chief engineer or is it to be paid by the secretary of government of the PWD department from his own pocket? We are concerned out here as regards the money of the state. Or does the state of Assam has so much of money that they can pay so much of interest? I don't understand. How is it possible that you are delaying this matter, that too when there is a direction? This is a very serious thing. If you don't have the money, this is not done. I think who has to pay? The chief engineer, PWD. Where is your office? Mr. Where's your office? Hangrabari? Where? Provide the details of your office. We'll attach that office and sell it.
Possible posted on my day after tomorrow or even at 2. I want
Get
to-
the instruction. And Mr. Saikia, you get these documents. You have submitted these documents, right?
So my lord, that my lord, he was supposed to place the my lord letter or my lord any document.
What letter is required?
No, in the,
If there is a delay out there, have you deposited in the court, the reference court, the amount? No, then
it is your duty to do so in terms of 31(2) of the Act. Then, now who is going to pay it? Tell me, either it has to be paid by the government, PWD department. The chief engineer has to pay the interest. Tell him. The chief engineer has to pay the interest from its pocket. How much is the amount? What much has gone? 7,91,748. That's the amount.
That's not, bill a certain date.
Then who is going to pay the remaining? The reference court order, the calculation has to be given now. Let this be, interest portion should not go from, let the state pay and deduct it from the salary of the chief engineer as well as the secretary, revenue department. I think better. We'll pass that order. If the state wants to say, look into it to that effect that they don't want it, it's okay. Then officers, all your officers will come into light. This is not done.
But they let it be day after tomorrow. I will come up with something, then what
You get the check. No, you get the check, a demand draft in the name of the mother. Who is there?
We have submitted that Rita Babu is the daughter of the deceased Prabhat Mohan. And we have submitted
Now
that
the amount has gone to 21 lakhs.
total 21 lakh is come to 21 lakh, but they have assessed only rupees 10 lakh. And we have given the details accounts by calculation.
Where?
My lord,
This is a serious thing. I'm not concerned about other aspect. I'm concerned about the money which is being paid on account of interest. Reference court's order is of 2001. My goodness. 15% interest. Who is going to pay? No, this type of calculation is no. And this is 2017. Another 9 years at 15% interest. 15% interest. Who's going to pay? No. The interest would not calculate from there. Interest will be from 2001. Not on the basis of that. Where is the interest amount? Interest at 9% for the first year from 1990 to 91. Then from 1991 at the rate of 12% at 15% on that amount, which comes to 8,61,000. Now, how much is the additional amount? Bag number is 12%, 12 lakhs of land. Land value is 6 lakhs per kaka. Quotes are there. It is 12,500. So 1,25,000. Irad value is 61,000. Total amount is 1,86,000. 30% scholarship. 12% interest. 2,56,000 is the total. Land value already paid. Now then value have been paid is this much, balance is this much. So on this, you are paying till 2017. Given updated status as on Friday and along with the check. And this interest has to be paid by the commissioner. Whoever was there all this while, the commissioner and secretary revenue department, as well as by the chief engineer PWD. On their pocket. The state will pay, or the state will be given the liberty to recover from their salary or pension if these people are there. This man. Monday you are getting the check. Monday, no. Friday you get the calculated amount. And Friday you produce the all the things, the power of attorney against whose name, whatever documents you have submitted, you place it before this court. We'll give it on Monday. You will get the check. We'll get it. And the interest has to be paid by these people because the state cannot pay. We have to think about the state, not because of these officials, lethargy. No. The present application proceedings, contempt proceedings, is directed against the willful and deliberate violation to the order dated 21/9/2017, passed in WPC number 5522/2015. It shocks this court to take note of that a simple direction passed by the learned coordinate bench in the order dated 21/9/2017 in WPC number 5522/2015 to make payment of the amount to which the petitioner the predecessor in interest of the present petitioners was entitled to on account of acquisition of land, and thereupon the reference court passing a direction for enhancement have not been complied with. It is also seen that the Deputy Commissioner Kamrup Metro have issued a communication on 18/11/2017, almost a decade ago, that pursuant to the award passed by the learned reference court dated 7/12/2011, in reference case number 160/1992, arising out of LA case number 11/1989. The petitioners were entitled to an amount of rupees 10,98,555. Out of the said amount, it is also interesting to know that the principal amount payable was rupees 2,17,931.79, and the remaining is the interest as on 18/11/2017. As on today also, interest on the amount of rupees 2,17,931.79 is running at the rate of 15% per annum. However, the concerned authorities of the respondents' departments are least bothered as regards that the payment of the interest is from the public exchequer is at the cost of the public exchequer and have been dilly-dallying the payment of the compensation on one ground or the other. The question as to whether the respondent state is required to take actions against these officials as the said amounts are being paid from the public exchequer at the cost of the public exchequer. This court leaves it to the discretion of the state government. However, this court cannot be unmindful of the fact that on account of the actions of the concerned respondent authorities for not making the payment, the public exchequer has been put into strain, have been strained. Considering the above, this court fixes this matter on Friday, on which date the authorities, the chief engineer, PWD, bracket R, is directed to GWPWR as well as the revenue in the party. As well as the revenue shall provide an updated calculated amount as on Friday to be the interest payable, to be the total amount now payable to the petitioners. Full stop. Failure to do so, this court will be constrained to call for the personal appearance of the chief engineer, PWDR, on the next date. This court also puts the chief engineer, PWDR, to notice that the said amount so calculated has also to be paid within a period of 7 days, failing which appropriate directions would be passed. Is the matter on Friday, showing it to be part heard. I'm not concerned with any.
No, regarding the document part, if they furnished in 2020.
Document he will get.
No, whether.
Forget about that. I am not on that. You get the document.
Right.
All the documents as regards those 4 documents they are asking,
Yes.
you get those documents. The council appearing on behalf of in order to cut out those unnecessary formalities which have been resorted to by the respondents in order to to delay the payment, this court directs the counsel for the petitioner to produce the 4 documents which have been sought for by the authorities so that the same could be handed over to the counsel representing the respondent on Friday.
Well, let him, my lord, submit
No,
before the-
no,
before the
no,
ordinance by
no,
Friday, then we can
no,
process it.
nothing doing.
No,
we'll
we
have
can
it.
process it, but.
We will hand it to the chief engineer PWD if he doesn't appear by hand out here, personal appearance. This is not done. It's serious. I have no problem with the other aspect, but which one of the state public exchequer being ruined on the basis of thing has to be. Yes, what is this?
Here, there was a direction by the honorable court to demarcate the land of the petitioner also. That has already been done.
Okay, none appears on behalf of the petitioner on call. Mr. So-and-so who appears on behalf of the respondent number 2 and 3 submits that the direction passed in the order dated 31/7/2023 in WPG number 4284/2023 have been complied with. Considering the above, the instant contempt proceedings stands dropped. You get the copy of the order. A copy of this order be provided to Mr. B. Gogoi, the learned additional AG during the proceeding.
Please, Your Lordship. As per my lord, office note dated 29/5/2026, service report is awaited against reference number 3, 4, and 10.
Learned advocates appeared for one appeal date, no AD card for 3, 4, and 5. What can I do? What is the direction? It's a litigation, contempt. And what is the case? What is the direction first? Let us see.
My lord, direction is that page, my lord, 29, my lord.
Huh?
Page 29, paragraph 24. my lord.
When you are better in the interest of justice and appropriate so and so, and now there will be a balance contractual amount that we have within a period and the date of the receipt of the certificate. 35 copy. Who is to make the payment?
My lord, response number 1 and 2, my lord.
We have to make the payment, madam. We have to make the payment. Madam, the scheme was sponsored by the government of India. Madam, they have stopped the scheme, madam. And we are regretfully demanding the money, but they have not paying us, madam.
Put it on the affidavit.
To that, madam, to that, your lordship, has maybe ever, madam, they have put an order, so we can make an inquiry. We have also done that inquiry.
What order?
We will file that affidavit in details, madam.
I have not filed any order.
No, not in this case, huh? Let's figure out matter, madam.
No, you put it on affidavit so that he can make those people party.
Yes, sir, we put it on affidavit.
Payment having not been made, then it will go away, that he, that you put it, that he is entitled to, but
Yes, sir.
we have
Yes,
been
sir.
pursuing. Now you see the judgment of, Jai Prakash, no? That they have passed an order, A.V. Jai Prakash. Recent judgment of 2025 of the Justice B.R. Gavai and Justice Marsh. So there it says that if you are not in a position to make the payment on account of something, some problem being there, if you mention it, we cannot initiate contempt against you. But as regards the others, we can. You file your affidavit. So Mr. So and so, the learned counsel appearing on behalf of the respondent numbers 1 and 2 submits that affidavit will be filed within 3 weeks from today. List this matter again on 27th of July 2026. In the meantime, the affidavit be filed on behalf of the respondent numbers 1 and 2. As regards the respondent number 3, 4, and 5, the respondent, the registry shall provide an update on the next day.
But your response is more important than us.
Understood. You file your affidavit.
All right. Service complaint regarding my lord, private restaurant.
4 and 5.
My lord.
What is your case?
My lord, regarding the demolition of part of the building, I am LOT of the
File challenging
my
the
lord.
order dated so and so issued by the chair DMDA, which was served upon the builder and the owner of the apartment of the Iman. And the builder is a resident of the apartment. Might be some deviation. Yes, what do you say?
I will take a private response is complete, my lord. I'm waiting for the instruction, my lord.
There is a stay order.
Yes, my lord. There is
So there is a direction, there is some deviation committed by builder.
Yes, my lord.
What is
Oh,
the
it's not-
deviation? Let us see. Why the matter is before the civil court also?
Yes, my lord, one civil court also pending.
Where is the direction? Includes.
Page 75. So,
75.
I copy to 70.
Action. You are there in an apartment.
Private, my lord.
Huh?
Private, my lord, private, commercial purpose, not my lord, private apartment, my lord. LOT, we are LOT, my lord, under the builder, my lord.
The builder is okay. I'm not on that.
My
The
lord.
building was, you purchased as what?
I am purchased from the respondent four, my lord.
Huh?
Respondent four, 40 branch, my lord.
Now in the regulatory, where is the,
Find the page number 21 is that.
where is the agreement? Where is the sale deed? Huh?
What's it, page 26 or what?
Where?
26, 25, my lord.
Where is the deed of sale?
Yes, my lord.
Niranjaniya Khalgi. Vendor is actually owner of a residence.
I am Hitumani Bhattacharya, my lord.
Like side. Now the question is, did you check that the building was proper?
Originally, I have not checked, my lord,
Then
because
you
my
cannot
lord,
get the
originally Chittaranjan Mukherjee was
So
purchased, my
what?
lord. Thereafter,
I'm not, if
purchased
he has
it
done
only.
anything, if you have
And my
told
lord,
him, go and ask him. You
he
have
was-
also gone to RERA. Have you not gone to RERA?
My lord. It's still not done, my lord.
Who has gone to RERA? Somebody has gone to RERA.
If lordship,
Yeah. Ruti Rangang, sir.
yes, my lord. Original 40 branch, my lord.
He has gone to RERA. You are there also a party.
Yes, my lord. 40 branch also part.
Complainant is Vicky Rangang, sir.
Vikiran, Yam,
She has complained against your
yes, my lord.
construction.
No, my concern are against the 40 branch, my lord. Vicky, respondent no file complaint
Your
against.
name is also there as respond number 5 in that RERA. Now what has happened in RERA?
It's pending, my lord.
Huh?
One case is pending, my lord.
What is the case out there?
What's it, page number 21, right? See. Yeah, the part 20, that's. Understand.
Oh, you have been sold the second floor. There's no permission. That is why. How can we allow this type of things? You have been only, the permission was given for ground floor and first floor. You did not check this very document. You cannot come and challenge all this. Mr. Demolish it. Give a report before this.
Provision of section 71 of the LD Act, appeal is also done. So that particular.
Better. Don't, here we can't help you. Withdraw with liberty to file it. They are more considerate people. I am not.
Yes. Hey, small people, my lord, small plate, my lord, 500.
So what? 1 inch is also big.
500.
You don't have the second floor without a permission. Now the question is, the question is, another aspect, Mr. Bora. My question is whether the required FAR, which is there, can be taken into, yes, you have non-compoundable, but in fact, in a very recent judgment passed by the Supreme Court, that there was a huge, if you have been to Bombay, have you seen that Piramal building? Huge mob. There was a direction passed by the Bombay High Court to demolish the entire thing on account of a branch. This is not compoundable. The Supreme Court said if this demolition is carried out, the entire thing, around 8,000 people will be losing their jobs apart from many other things. So they imposed the cost of around 79 crores for regularizing. That was one bill. Now the question is whether this particular type of building with the area as per the building bylaws can be regulated.
What the thing to, this is only to, it will make an application after section.
You have rejected that.
Then
You have rejected that. So you go file an appeal. Take up this type of plea. Not here. I can't do it. You go and file an appeal. That is the way. Take up the help of that gentleman. And come up that this is not going to, because they need to change it. A very important question arises. Now what has happened? At one point of time, the building bylaws where the houses were being made, it was ground plus 2 or ground plus 3 granted. Now they are giving it to ground plus 7 also. It is permissible because now it is more relaxed.
now,
Relaxed. So then why it can't be regularized if it is so? This type of matters, then only I will pass orders. Please, repeat. Heard Mr. Soik. Soik, the learned counsel appearing on behalf of the commissioner, Mr. Hezbollah appeared on behalf of the DMDA. Number 2 and 3. One, so. Mr. Hezbollah, the learned counsel appearing on behalf of the respondent number 2 and 3 submits that against the order dated 27/1/2025, the petitioner has an appellate, has an effective and has an alternative and efficacious remedy in terms with section 71 of the Gauhati Metropolitan Development Authority Act 1985. Mr. S. Seika, the learned counsel appearing on behalf of the petitioner submits that if the petitioner is now relegated to the appellate authority, there is it would be relegated to the appellate authority, the appeal would be delayed. And as such, the petitioner would not be able to get any substantial relief in the appellate forum. The learned counsel appearing on behalf of the respondent number 2 and 3 submitted that the said respondents, if an appeal is being filed, would not contest on the question of delay. Considering the above, this court therefore closes this court, considering the above, as certain questions of facts are to be adjudicated, it is the opinion of this court that the appellate authority under section 71 of the Act of 1985 would be best suited for deciding the issues against the order dated 27/1/2025. In that view of the matter, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands closed. However, it is observed that the not entertaining of the instant writ petition shall not preclude the petitioner to avail remedies under section 71 of the Act of 1985 before the appellate authority. It is further observed that if the appellate petitioner herein files an appeal within a period of 30 days from the date of the present order, the appeal be decided by the appellate authority on merits without insisting on the point of limitation. This court further taking into account that taking into account that if there is no continuation, if the interim order so passed in the instant proceedings is not continued for a period of 30 days from today, thereby enabling the petitioner to file the appeal, the entire proceedings would become infructuous. Accordingly, this court therefore observes that for a period of 30 days from today, the interim order passed on 16/5/2025 in the present proceedings shall continue to serve. Thereupon, it shall be absolutely within the domain of the appellate authority to decide as to whether there is a requirement for passing a stay order or not. What is this?
Plus, as per the last Lawazim order of 8 June, the services upon the private respondent is complete. 8 June.
Service complete.
Yes, sir.
Respondent number 678,
5, 6, 7, and 8.
all complete. The service being complete, list this matter for admission after vacation. Okay, what is your case?
Plus, we have challenged the cancellation of a mutation in my name, without giving me any show cause notice.
No,
I was not even furnished with the show cause notice.
it is matter for admission on after vacation. 22/7/2026. The interim order.
There is a status quo order. Plus.
Passed on 23/7/2025 shall stand extended till the next day. That case, I will. Have you know?
Also,
What is this? Insufficient address.
Also, I
Not
will be allowed
taking
to
steps
withdraw
upon the respond number 5. Who is respond number 5? Submitted to the address are accurate, but they wish to serve until by the. Okay, you want to take steps by the state.
Also, I may be allowed to withdraw this.
You want to withdraw the petition? Mr. So and so, the learned counsel appearing on behalf of the petitioner submit that he has instructions to withdraw the instant petition. Accordingly, the writ petition stands with closed on withdrawal. Interim order passed on 19/12/2025 stands vacated.
You know what I have filed? Right, yesterday, that has to be tagged.
What is this?
Record list criminal.
You are against the status quo?
Beg your pardon.
Since this order has been passed down without intent, the same be considered on the return after taking the instruction. What is the order?
Order was not to disturb my peaceful position. No, what happened in this case, you know? The government took a decision to acquire a 5,000 acres of land. Decided to acquire. Then they adopted the Decretion and Acquisition Act 64. They issued notice for the purpose of APDCL, is a company. Then under section 3, what happened? The government can requisition the land for a company if the company formed for rehabilitation and resettlement of land, displaced person. APDCL is not a, and when the government decided to acquire the land, whether 64 Act can be resolved. Because 2013 Act provides
I understood, but today we are on the contempt.
on the Miller, therefore what I say, can it be heard along with the writ petition, Miller? It is better.
But your position has been taken.
Already evicted. And therefore we have to finalize the writ petition as well as the contempt petition put together. So that I will get the relief. Because
When was the interim order passed?
interim order in 2025. Order dated 1/8/2025.
And when did they evict?
On 6/1 below.
Huh?
6/1/26.
They've been evicted?
Yes.
Boundary wall before, boundary wall after. And it was before or after. Very clever.
Therefore, what I pray, my lord, the lordship, yes, for me, so can I have it both writ petition and the contempt?
Better. Okay. What is the affidavit filed by the respondents? They said that they have not evicted from the land. So who is in possession? Are there issues eviction notice? Are you disowning the annexure 6 to the contempt notice?
My lord, document kindly see, my lord. Page 11 of the contempt petition. Page 11 of the contempt petition, honorable court, paragraph 5, if I may read it, my lord. After hearing, it is provided that peaceful possession of the petitioner over the plot of land should not be disturbed till the next date of listing. Since this order has been passed at the motion stage without instruction, the same would be considered on the returnable date after obtaining instructions by the learned state council. Now that writ petition is pending. They have now alleged in the.
No, thereafter page 15.
Page?
Page 15.
Yes,
This is extended to 11:9.
yes, now,
Wait, then you come to page 19.
yes, my lord.
It is on 5/1/2026. In
5/1,
time order passed earlier shall continue till the next day.
Yes.
Now, my question is 11/9/2015, another order, page 17. Here, 11/9 says that the interim order passed earlier shall continue till the next date of listing.
No quarrel.
Then why did you issue 21? Page 21.
Page 21 is my lord, so far, annum it was issued, but he was not, my lord, this peaceful possession has not been disturbed. Some other persons, nearby persons who were not reported to I would vote, because several persons are in occupation. So we have evicted other person, that is what we have categorically stated at paragraph, my lord, 6, page 32 of my affidavit. Page 32 of my affidavit, my lord. Kindly see, my lord, page 32. It's a part of paragraph 6. Page 32 down below, my lord. Page 32. Consequently, eviction notice dated 3/1/26 were issued and directed to vacate the acquired land within 3 days. Accordingly, eviction proceeding was lawfully carried out on 6/1/2026 and completed in respect of other persons and not the petitioner.
Ransom manner, page 36. Page 36. Will be. Page 36.
Page 36, yes, we have. That. Land record staff, my lord. Because we have.
Within whose land?
It is the petitioner's land.
So why is he standing out there?
No, you have to, my lord, prove. Is it necessary, my lord? That some person, he is a witness to this photograph, and this is a geotag photograph. Lordship will kindly see. So we have categorically stated, my lord, that
How do you know that that is the geotech location?
it is there, my lord. Kindly see, my lord, it is there. 67 Q plus M3, this is the geotag location.
Okay, we do one thing.
So this is the case of oath against oath. On oath we have stated.
No, another thing is, with due respect, Mr. Kabuki. One thing maybe I have done civil matters, so I understand. Whenever there is a holder of status quo in respect to a land, unless it is being specifically identified in the petition, they have to mention the schedule of them. Should have been given. Because otherwise it would be a vague one. Still remember that on the judgment of the status quo cannot be given. To be a clarity. Anyway, we do one thing. By the reply out there, we need to sell up with that whole. The repetition, the schedule is not mentioned.
The minor will not follow. Effective by one hearing. Here is very in contempt, my lord.
One have to see. When the petitioner has, when the order is being passed out not to disturb the petitioner's peaceful possession. The order, if it is vague, unless it is identified as to which area, which should have been given out there. If it is not given, then can there be a case of willful and deliberate violation here? This can be seen from the petition. Am I wrong?
Then the instant application for the purpose of appreciating and deciding the present the content proceeding. It is the opinion of the court that the records of WPC number 4318 of 2025 could be required. It is also brought to the notice of this court that the WPC number 4318 of 2025 is presently pending. Considering the above, this is content application along with WPC number 4318 of 2025 on 3rd of August 2026. Next item, similar result, only WPC will be saying number 432125. Where is that? Next item, I don't see. I can take it. Only WPC number will be saying. It will be 4321. I don't know. I'm so offline. It is an application file relating willful and deliberate violation to the order dated 25/7/2025 in WPC number 2878 of 2024. The directions of the learned court bench of the court is contained in paragraph number 6, 7, and 8 of the order dated 25/7/2025, which will be produced during under. From the above directions, it is seen that a period of 6 months was granted to the Revenue and Disaster Management Department to take a final decision on the proposal submitted by the Deputy Commissioner to brief by communication dated 30/7/2024. At the period of 6 months had elapsed, the instant contact application has been filed. Then when the matter is taken up, Mr. A. Bhattacharjee, the learned standing counsel of the Revenue and Disaster Management Department, has placed a communication issued by the additional secretary to the government of Assam Revenue and Disaster Management, SNS Department, dated 16/6/2026, wherein it is mentioned that the department is actively pursuing the matter and necessary steps are being taken to place the proposal before the cabinet at the earliest opportunity. The same communication is kept on record and marked with the letter X. This court adjourns the matter, thereby enabling the respondent hearing to take effective steps as per the directions contained in the order dated 25/7/2025.
this matter again on 7th of September 2026. In the meantime, if the respondent authorities are not taking effective, in the meantime, if the compliance is not effective, this court would be constrained to pass appropriate directions. It may not be lost sight of that the directives passed in the order dated 25/7/2025 was to complete the entire process within a period of 6 months.
Obliged.
What have you done?
Your lordship, it has been complied with. His account is now operating.
Mr. M. Sharma, who appears on behalf of
One and
the respondent number 1 and 2, submits that the judgment and order passed by this court on 1/4/2026 in WPC number 182/2026 have been duly complied with. Inasmuch as the petitioner's bank account, savings bank account bearing number 33,260,150,124 have been decreased by keeping a lien on the amount of 10,600,126. Considering the above, the incident content application.
No, my lord. Why am I not keeping, instead of keeping my lien amount, rather than deductive? Instead of keeping the lien amount,
It's a separate program.
rather deductive. And
However, it is observed that the amount of rupees so and so shall be kept in lien and shall be subject to such instructions and directives that may be passed by the respondent number 6.
Your
There is therefore a direction that if that amount you cannot take. If they have deducted that amount, the fact that that amount have been deposited is not in doubt. That was never your amount.
No, your lordship,
Not
directed-
deducted.
your lordship-
I clarify, Your Lordship. His lien is on 10,260. And on the date of when the lien was marked, his account balance is 1,100. So I have to maintain 10,600. Now his account is in minus, that is 9,900 something.
your
Still,
lordship-
he has to give deposit
Madam,
of the same.
Page 17, madam.
That is,
Can I approve the page 17, madam? For your February 3 to madam, May 30, madam. I have balance amount of 11,000.
Ah.
And your lordship directed, the order,
A
madam.
lien on this 10,000. Then
Then, my lord, now, my lord, account was shown as negative. Balance is negative.
it is 1,100, not 11,000.
No, 11,000, page 17. Balance one, 11,000.
11,000.
This is a pure form, February to May 2026. You are also directed to keep the clear amount. And my lord, now showing my accounts as a negative balance.
Where?
Well, page 16, my lord, is negative. 9,000. Instead of high court also, they cannot deduct 5,000. They have to keep the clear amount. Now showing my account as a negative.
Why have you deducted?
Not deducted. We have not
You have
deducted.
kept a lien. It was
Only on
11,000.
10,260.
No, it was 11,000.
11,000. Yes, sir.
If it is 11,000 lien, 0, so and so available to spend is minus.
But your lordship.
Did you get any instruction from the respondent number 4 and 6 to take that money?
No, your lordship, there was no deduction still in the account. His balance was 1100.
11,000.
So your lordship, there is some issues. I have to clarify this one. But there is a statement made at page number 7, para number 7, page number 5. Petitioner himself has made any statement.
Yes.
After deducting 9,000, 9,300, 16.
Pair number?
7 years. But his account is showing as on today 9,369. as per the statement of account. His account is operating, no doubt.
But how can you say minor?
That is because your lordship, 10,260 and his balance is 1100. So
Balance is not 1100, it's 11,000.
then I have to, your lordship, I may take instruction.
Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2 submits that he would like to file an affidavit in the instant matter. The learned counsel submits that the petitioner's account pursuant to the judgment order passed by this court on 1/4/2026 in WPC number 182 of 2026 have already been decreased.
Yes.
Thank you. The income of the limit appearing on behalf of the respondent number 1 and 2 submit that pursuant to the order dated 1/4/2026 passed in the petition number 182 of 2026, the petitioner's account has been decreased. The Econiga, the learned counsel appearing on behalf of the petitioner, submitted that while this court directed to put a lien on the amount of rupees 10,266.26 paisa, the respondents have shown the petitioner's account to be in the negative of an amount of rupees
9,369.30.
9,369.13 paisa. Though at the relevant point of time when the account of the petitioner was frozen, the petitioner had a balance of rupees 11,813 831.12. Mr. M. Sharma, the learned counsel submits, appearing for the respondent number 1 and 2 submits that he would like to clarify by filing an affidavit. Is this matter again on 17th of July 2026. In the meantime, the affidavit be filed on or before 15th of July.
Case, because of some discrepancy in the CIF and the petition regarding the respondent, we could not take steps. However, my lord, she has appeared on instruction. I'll give a copy to her during the course of the day.
What is the matter about?
Non-payment of contractual fee.
How much?
34 lakhs, 30,
You
Yeah,
get-
3,000
you get the money from whom?
my lord, it is the Assam Tourism Department. It is they who have.
Yes, verify and pay within 6 months.
The lordship actually have not received a copy in this matter. Yes.
Yes, really the certified copy. Pay. When pay.
Lordship, I have to actually peruse the documents and I'll also have to seek instructions.
I'm not asking you to pay the amount. I'm asking you to verify and pay.
Yes, your lordship.
Verify and pay within 6 months. The payment made from our order. First, you verify. If he has given all the documents, including completion certificate, everything is in order. After verifying, if you find that he is entitled to this 34 lakh or any amount, then you pay within 6 months. If there is nothing, on him, you are not entitled to.
Put a reason order.
No reason order. Inform him.
Obliged, your lordship. Obliged.
Give your name with the payment.
Yes, nobody is appearing. Admission 2018 matter. Payment has been made, na? If none appears on behalf of the petitioner. This court duly takes note of that by an order dated 10/3/2026, there was a direction passed upon the respondent of court to disburse the amount to the petitioner upon submission of the necessary documents. Have you got the money?
No, my lord.
They have not turned up with the document. They have not turned up with the necessary document.
And even when yesterday we visited my lord, they informed me that we will deposit the amount. All documents have been complied, my lord.
Bank account has been given, you have Bolen Kolta and Dinesh Kolta.
Yes, Bolan quality and Dinesh Kulkarni.
Payment has been made.
No, my lord, the last part, my lord, last column, my lord, amount sanctioned and to be released, my lord. It's still not been released, my lord. As per my,
This one.
this is the asked to me also, my lord.
Now, this order has been given to whom? The branch manager, you get the money.
And even in this account, my lord, we even in morning, my lord, we confirm, my lord, no money has been transferred this account, my lord.
What?
No money till that, till now, my lord, not been deposited
You
in
get
that
the money. They are giving an undertaking. The amount will be paid. That remains only. Heard Mr. So the learned counsel appearing on behalf of the petitioner. Now, why are you saying that no documents have been given? Then why no documents have been made, then why you are directing the bank manager to make the payment of these 36 lakhs?
That contraction, when I take instruction,
But this is when happened.
Yeah.
It happened just now. So therefore now you are, he has submitted all the documents. Why you are making the submission? Heard Mr. So the learned counsel appearing on behalf of the petitioner. So appears on behalf of the respondent number. Respondent numbers? Or you are not aware?
4-6.
4, 5, and 6. IIT? You are appearing. Mr. Who appears on behalf of the higher education department. And who appears for the central government? Higher education department is no. IIT, who is appearing? Anyway, one so appears for respond number 4, 5, and 6. The question involved in the instant proceeding is as regards the non-payment of the land acquisition compensation to the petitioners.
Dinesh father. Dinesh father.
Is he alive?
He expired.
So how is it possible now? Have you been substituted?
They are implicated.
Have you been substituted or not? Is the petitioner's father expired? Has he been substituted or not?
Substitute, madam, substitute.
Then why you are saying not? Unnecessary don't make sense. On account of non-payment of the land acquisition compensation to the petitioners. This court had passed an order on 10/3/2026, taking into account the statement made on behalf of the respondent numbers 4, 5, and 6, that the petitioners are entitled to the compensation. However, there is a requirement of submission of certain documents. In the said order, this court specifically directed the respondent authorities to disburse the amount to the petitioners, subject to the petitioners submitting the necessary documents.
The matter thereupon was listed on 8/6/2026. When the counsel for the petitioners sought for instructions for time to obtain instructions as to whether the amount have been paid or not. Today, Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 4, 5, and 6 submitted. 4 and 6. 4 and 6 had submitted that the petitioners have duly submitted all documents, and in pursuance thereto, the district commissioner Kamrup Aminga have directed the amount of rupees 36 lakhs 02,602 to be paid to the petitioners in total by debiting it from the account of the district commissioner Kamrup Aminga. In that regard, the order dated 12/6/2026 have been placed on record, which is kept on, has been placed before this court, which is kept on record and marked with the letter X. Considering the above, that there is a direction passed to the branch manager SBI ICD Amindam branch to take necessary steps for electronic transfer of the total amount of rupees 36,02,602 to the petitioners herein in their respective bank accounts of the two petitioners herein in their respective bank accounts mentioned in the order of an amount of rupees 18,01,301 each. Nothing further remains to be decided in the instant proceedings. Accordingly, the reputation stands closed. This court, however, grants liberty to the counsel, to the petitioner. In the circumstance, the said amount is not credited to the petitioner's account within a period of 30 days from today, to file an application in the instant proceedings so that the proceedings can be revived. Yes,
So for 17 is function, but I'm doing on 17, my lord, already there is a order passed by dishonorable court. That is not been complied with by the authority, my lord. And they,
you are not allowing Madam Hazarika to take the podium.
my lord,
You are not allowing Madam Hazarika, who is just on the back.
Hazarika was telling me, you have a major role. I said, I know, you have a major role.
Yes, what is the case about? What is the case about?
17, my lord, already there is regarding my demolition of my lord, unauthorized construction of that NK building, my lord, in Kahilipara. There is already there is a order passed by your lordship, my lord. That order, my lord, your lordship kindly see.
Which one? Who is that the case?
That case, my lord, what, your lordship kindly see the
Oh,
order
by the way, that
18,
day,
11,
I was
22.
just thinking,
No,
what happened to this?
what happened, my
day?
lord?
In fact, that day I was going on by that road, I was thinking what has happened. I could see there are a lot of some hotel or it has come up.
My lord,
It's a hotel now.
yes, hotel still, my lord, they are running. Even, my lord, yesterday,
one of the my lord, that person, he went there, my lord, he is enjoying the foods and this is the bill, my lord. Still, my lord. This is the restaurant bill, my lord. So hotel is still going on, and my lord, what happened in pursuance to the order passed by your lordship, in the municipal authority issue notice to the builder and my owner. But that has been challenged by some other person before this honorable court. In that case, I am not my party member.
Which one?
Municipal authority,
Passed an order on 18/11/2022.
my lord.
Stating here thereby directing, I shall hereby undertake, and therefore I directed it, the building cannot be used for commercial activity of area permits unless till GMDA of the GMC permits the conversion. Now then, one time, at one point of time, somebody came up. I
Sorry,
think
but
it's the GN Sahewala.
Jane Salad, and that is, that order was, my lord, it is a,
GN Sahewala was the council who came up and said that, look here, there is a marriage in our family. Let kindly allow it to be used.
that is, my lord, on 11/9/2023. There is a order passed by your lordship in this case, my lord.
11/9, yeah, 11/9/2020.
So thereafter, what my lord, authority done, my lord, they issue notice, simply. And that notice, so cause
But
notice,
it was fees. I deeply, I had sealed it.
yes,
Then what happened? Order passed herein above shall not affect the power of EF to take effect against the transgression of EF. The above exercise of resealing of the EF be completed within 48 from the payment of demand pursuant to the building document. Sealing.
thereafter, my lord,
Can be dealt with. Who is the response number 7, 8, and 9?
my lord, their council is there.
So I remember, my lord, this was initially, it was on a residential complex. This particular hotel was done. Thereafter, my lord, it was stopped. Thereafter, it was sealed. Thereafter, we moved an application because his son's marriage was there. It was de-sealed. Thereafter, again, it was closed. Then thereafter, there was a recollect, then with the guest house which was made. Then there also it was stopped.
Because I passed an order.
Yes, it was stopped. Now, my lord, what I have been told, my lord, after a long time, I have seen there is a homestay. Homestay, my lord, an application was made and trade license was issued, and he is allowed to run in a homestay. Homestay, what I have been told, my lord, under the law, the homestay is allowed, my lord. We have to bring notice to.
We do one thing, we get hold of the commissioner, GMC, and direct him to do something, close this thing. Which can happen. Be serious. Man. In fact, the matter has gone out of my hands. That is why we. Who is Papoli Soikia? Madam, you are appearing for? Who are you?
For the petition of Papua Soikia.
Who are you? Who is Papoli Soikia?
My lords, basically we are the group of homeowners, the flat owners, who are moved an application because we are being aggrieved by an order passed that our occupancy certificate has been cancelled, my lords.
You are in the other block A and block B.
Yes, my lords. The flat
Which
owners
block are you?
they're both, my lord, A and B.
Huh? Block A and block B.
A and B.
That has been cancelled.
Yes, ma'am.
Block A and block B. And what about the other one? Here, I think this is the matter by R.P. Cooper. Where is he? Yes. He wants the regularization of something. But Mr. Naik, how? Spite of there being an undertaking given before this court, how they are now using the petition?
file it. No, in fact, the day I was going by that road, then I saw him running, I thought, "Charlie, petition must have been dismissed. It must have,
Well, if your lordship looks into an order of 7/2/2024, please look the order of 7/2/2024. Bottom lot of writ petition. Please see that is 4389 of 2020. Okay. In the writ petition, 7/2/2024.
if we took on so and so submits that there are two connected repetition here. It obtained that the outcome of the state will have an impact on the present and as such, this would direct the instant repetition to be listed along with. And
Second part, it is the opinion of this court.
that the outcome of the state repetition will have an impact on the present repetition. And as such, this court directs the instant petition to be listed along with those.
Yes.
Now, the reason is this. Mr. Arvind Kukon's client was the bidder. He wanted to regularize. That is his proceedings in that relation, one of them. Now, here is a case where the petitioners in the main petition, the petitioner's case, if I remember correctly, they have certain problems as regards Block A, Block B, and more particularly as regards Block C. And Block C does not have a commercial, nothing has been given for commercial
In all residential,
carrying on any business on that.
residential.
And that is the reason why I passed an order to seal it initially. Then I passed an order to deseal because of the marriage business. Then with an undertaking that they are not going to use anything, that order has not been touched anywhere. So under such circumstances, how are they running on the basis of the GMC? Unless the GMC does not authorize, regularize this construction. GMC issuing a trade license or if GMC tomorrow today says issuance of a trade license by us amounts to giving construction permission, it is. Is it okay? No, now you have a homestay license.
Homestay.
You have given another homestay. Now I understand. Because Mr. Nath, one matter I was taking up of some homestay nearby. Now, this was a case, what has happened is, when you file an application, you can file an application for a trade license online. And you apply and they give it on the basis of ease to doing business without going for much verification. So there was a trade license being granted. And in fact, here also, initially they granted something for rest house or something out there.
Guest house.
Guest house. No, earlier. After the hotel.
No,
it
your
became-
hotel was there.
Hotel, the hotel is closed. Then
Then it was sealed. Then we paid because his son's.
no, then they
sealed.
use it
Then
for
it
some
was
guest
closed.
house.
Then thereafter, my lord, guest house. That
Guest
was
house is closed.
That is closed.
First they gave it for guest house.
Yes.
Then I took it up. How
Yes.
could you grant it?
Then it was
Then
closed.
they cancelled that guest house and now you are taking a homestay. Right.
That's the position of
And
the court.
whose home is there? To
I'm
have a homestay? It goes very much against it. Huh? He has to stay there, huh?
He stays.
Basic intention of a homestay is that it should be your own home. Where
Almost
there
like
is a particular area being given out there for people to reside.
My lord, landowner, no, he stays there, man. That area also is essential.
Okay. We do one thing, matter of. As regards A and B. Oh, now you are now stepping into the shoes of Mr. R.D. Kumar. Yeah. Yeah, it's okay. So therefore, your case is of 240. 240. Your pleadings are complete. Who? It is the JMDA who has to file. Are you filing your affidavit or your affidavit out here in 4389 with the cover? So you do one thing. And there, employee factors, you think that the occupancy certificate have been cancelled. They say you are in block A, block B.
Why not? That woman's a resident in the. You know, just it must be cancelled, expected entire.
And Mr. Mohanto, your case, I think you have to be a bit lenient on A and B. People are
Yes,
residing.
but commercial activity cannot be, my lord, there is no
No,
permission for
no,
commercial activity.
not on C. I'm not on C. I'm not saying. But as regards A and B, you have to be lenient. There are a lot of people who have purchased the
Because
flats
now
and all.
still
Now, now
and-
the question is, we can very well apply the law as recently, which I was saying, of recent judgment pertaining to the pyramidal thing that happened. So there we impose some cost upon them to do something around 15 or 30 crores. 30 crores upon the Mrs. Hazarika's client to be paid to them as compensation. You regularize A and B. But C, not possible. You are ready to pay. You give an undertaking, you pay 30 crores. Okay, A and B, we can think about regularizing by taking into account the recent judgment of C. But C, no. Bishops. Now. No, they'll have to, by breaking the wall, it can be done. But madam, your C is gone. Your C is nowhere.
There's no permission. Then without
That you can demolish it. C also, anything unauthorized you can demolish, or if it cannot be regularized. Because this court cannot pass a direction for regularization which
Which is
goes
not
against the statute. I can't pass that. Now, only thing is, how do we take into account the judgment of the Supreme Court in that pyramid? If we can do something to that effect, how it is, but then also you have to close down this. Who is paying for that sea? Who is having the guest house or homestay at sea? Mr. Who is having the guest house in sea?
Not in guest house, my lord.
A homestay.
A homestay.
You are having.
Yeah, I am having.
Close it down.
No, whether it is permission, no, I will show it.
You
my
have
lord.
no permission to.
No, I will
And
show it.
we
No,
have-
permission is given by
No,
trade.
Mr.
No, my lord, it is given by trade license is granted. I'll show it.
Trade license under no circumstances when we
Homestay.
construe.
I'll
Unless,
show.
unless you admit, can be a trade license be construed. That is what.
Let him verify,
We
cancel it.
pass that order for C, immediately close or seal. You seal it, seal. Because they are not entitled to use it. Because they are every time, first they get out to do it a hotel. Hotel close, then they mischievously apply for this through online through this particular, what you call, guest house. Guest house gets closed because you cancel, then they have a homestay. Yes. We ask him also to be arrested and brought here. It's a violation of undertaking.
No, if a restaurant is going on also, not only that, hotel and restaurant. This is the, my lord, your lordship kindly see if required, I'll.
This is not a restaurant, no, it's a homestay where.
No, no, this
food
is, this is
given.
the, this is the food bill.
My lord, he has given now. We'll give a reply then. We'll give a reply, my lord.
We
No, I am not
immediately ask
asking
him
that
to-
case.
Yes.
Anyway, let me pass on.
Yeah. No, no.
I'll file, my lord, even then I.
No, there cannot be any homestay or anything. No homestay.
I'll file an affidavit. Let me file an
I'm
affidavit.
closing it now.
Let me file an
No, This is
affidavit.
a violation
Bring
of the
notice.
undertaking given before this.
No, only guest house, my lord. This is
No guest
commercially.
house, no guest house, nothing. If you want to stay alone, you stay. Nobody else.
My lord, homestay, my lord, I'll show.
It
before
cannot
this
be a homestay.
Homestay, it is permissible. I'll show it before this court.
How?
I'll
Show
show
it.
it, my lord. Give me a time, my lord.
No,
I'll
I'm
show it.
showing it. Now I'm
Right.
giving you have 50
Under the
minutes.
trade,
Show me. What is this homestay business? We close it.
permission is not required, my lord, in a homestay, my lord.
When the building is, can you have a homestay? Can you have a homestay? What is the meaning of a homestay? Let us see.
The landowner is there.
What is the meaning of the homestay? No. You say it to be,
Stay.
you are saying it to be a homestay. Guest house, you are not permitted. Hotel, you are not permitted. Now you are saying it to be a homestay. What is the meaning of a homestay? That's it. Else I'm closing it.
No, we'll give an affidavit to the extent that we are.
You say that no, the more
We'll
matter
use
has
it.
come up before this court now that you are running a homestay. Now show me what is the meaning of a homestay.
No, there is no provision as such, my lord.
So
for
therefore it is
stay,
in the sense that homestay means what? We close it then. It cannot be a homestay. You are still using it for commercial purpose. Are you using it for commercial purpose or not? My question is this. If you are using it for commercial purpose in a building which is not for permissible for commercial purpose, then it is.
my lord, guest house may not be permissible. Hotel may not be permissible as residential premises.
Is homestay permissible?
So there is no answer there whether it is not permissible. But directly, so for a hotel, guest house is not permissible, my lord, in a residential. There are a lot of residents I have seen, my lord, where the homestays are there. It is not there in a residential places where homestays are there, my lord. That's what I am submitting, my lord. In a residential places, homestays are there, my lord. But guest house.
So
hotel
what do
may
you
not be
have in the
permissible, my
homestay?
lord. I'm sorry.
What do you have it in the homestay?
Homestay, I also stays, my lord, where some bookings are made, my lord. It is not a, my lord, it is not a guest house as such, which is not permissible, my lord. I have
What
seen in residential place,
what is there in the homestay?
my lord, the lodging is there, my lord.
And
Lodging is there.
that is the same thing.
Yes, lodging. No, that cannot be commercial, mister. My lord, then, my lord, if here.
You don't
Sultan
take
Bazaar-
money. You don't take money, I suppose. Homestay.
The money is allowed, my lord. Now, how can I say?
No, you cannot have a homestay
Money
in a
is allowed,
place which is and use it for commercial purpose by saying it to be a homestay.
my lord, I will show.
How many rooms you are using it for homestay?
Instruction now.
Okay, Friday.
Yes.
Heard Mr. T.J. Mohanto, the learned senior counsel, appearing on behalf of the petitioner. The learned counsel appearing, senior counsel appearing on behalf of the petitioner submits that this is a case where an undertaking which has been given before this court pursuant to the orders being passed by this court have been flagrantly violated by the respondent number 7. The learned senior counsel submitted that the block C, that amongst the 3 buildings, the block C, there was no permission granted for commercial use. On account of using the same as a hotel along with a restaurant, pursuant to orders passed by this court, the same building was sealed. Subsequent thereto, an undertaking was given by the respondent number 7
18/11/2022, undertaken. 18/11. Pursuant to an undertaking being granted by the respondent number 7 in an application filed being IAC 3363/2022. Permission was granted by this court to allow the said respondent number 7 to use the block C for the residential purpose on account of the marriage of his son. The learned senior counsel further referred to the order dated 18/11/2022. And more particularly, the directions passed in paragraph number 6, Roman 1. Roman 2. Roman 3. Roman 5. And Roman 6. And submitted that as on date, the respondent number 7 in flagrant violation to the undertaking given by this before this court is still continuing with the hotel business, either in the name of a guest house or a homestay. This court finds it very relevant to quote clauses Roman 1, Roman 2, Roman 3, Roman 5, or paragraph number 6 of the order dated 18/11/2022. The learned senior counsel further referred to the order dated 27/9/2023, whereby this court passed strict directions against the GMC authorities in providing a trade license to the respondent number 7 for carrying out a business of guest house having 16 bedded to 30 bedded bracket air conditioned establishment. This court also, during the course of the hearing, inquired with the learned standing counsel of the GMDA as well as the GMC, Mr. P. Naik, as to what happened to the said trade license. The learned standing counsel of the GMDA and the GMC categorically submitted that in pursuance to the order passed by this court on 27/9/2023, the said trade license was cancelled. This court also heard Mr. Didas, the learned senior counsel, appearing on behalf of the respondent number 7, who submitted that at present there is a homestay but not a guest house or a hotel. What's- This court inquired with Mr. Didas, the little senior counsel, as to whether a homestay, as to what would a homestay mean? And can there be a hotel? And can there be a commercial business carried out in a home, in a building wherein there is no commercial permission granted? By just having a trade license of a homestay. Mr. Pinayak shall also obtain instructions in that regard. Mr. Dida, the learned senior counsel, appearing on behalf of the respondent number seven, na? Seven or seven and eight. Seven and eight. Submitted that an affidavit would be filed in that regard. List this matter again on 15th of June 2026, 22nd of June 2026 at 2 p.m., showing it as part heard. 23rd, you have your Advocate General picking up on the entire matter. Then you have another 3-4 matters which are all. No, but this court have been taking it up in the matter as Block A, Block B, Block C. So therefore, this will be a Block C. We are considering it. Okay. We'll take it up on that. That's fine. So we'll take it up on that. You can very well make the submission. Huh? We will see whether it is there. If we ask the entire building to be demolished, the block C to be demolished, then your 19 becomes instructions. Others, A and B, I will regularize it. Don't worry. A and B, I will regularize this by demolishing the only those times. Smaller things can be removed. But no, and more particularly, there are people residing there, but not blocks. Block C has to be. And we will take it up if there is violation of an undertaking. Can you obtain what is homestay? Homestay is very important because you see, they use it as a hotel, the same establishment. Then they use it as a guest house. Same estate.
No, issuance of trade license itself says there is a trade. Trade means business, my lord. They are using for business purpose, my lord. Trade
And
license.
now they say
They have a trade license.
so we'll clarify.
Trade license.
It is a commercial activity. Yes. And can there be a homestay? What is the magnitude of a homestay? He has a 30-bedded room. Can there be a 30-bedded room of a homestay? And I think Mr. Das's client is something like the Sultan of Brunei. Anyway, he stays there itself. His
I'm saying, not
his client stays there. By any chance, was that bill yours?
no, my lord, no, my lord. No, my
His client stays. That's the whole problem. His client stays there in that building. Which one? His Gautam Local stays there itself. See, yeah. He's a C-floor. He stays in A. He stays in A.
No,
That's why he stays.
But
Oh,
only
you-
the upstairs is my lord seventh floor and my lord building C. C is my lord that cannot be used for commercial purpose. There is no permission, my lord.
Hey, don't worry, don't worry. Now this matter will be with me.
My lord.
I'll know
Yep,
how
yep.
to take it. Clear up, it won't get deviated.
Please, the lordship.
Yes.
My lord, the matter relates to the, my lord, victim compensation, my lord. The petitioner's father, my lord. It is a, my lord,
Victim compensation.
victim compensation.
Why haven't you got it?
What, my lord, in terms of the notification dated 18/10/12, page 20 to 23, my lord. And then revised notification, page 24 to 25. But original, my lord, emerges from the Act, CRPC, my lord, section B57A, my lord. That is the scheme of compensation. There, my lord, page 20 to 23. It was, my lord, earlier 2 lakhs, then by notification 2019 has been enhanced to rupees 5 lakhs.
Yes, madam, why haven't you got it? That is wrong. This order which has been passed by this one. The fact is that a person may get out, be acquitted on the ground that the state has failed to prove beyond reasonable doubt that he is the person concerned who is required. That is a different thing. But whether the question is whether he's a victim, the issue.
Lordship, let me just, I have been impeached as a party respondent only just by way of the last order. I was made a party in this. I was told to get the instructions in this particular matter. If I have just checked up the records of the case and there's an affidavit filed by the file on 14/6/2021, Your Lordships. By which the order passed by the DLSA has been brought on record, Your Lordships. Lordship will kindly peruse page number
Order.
42 and 47. By way of that order, 4/2/2021. Affidavit in opposition filed by the respondent number 2, page 45 to 47 on 4/2/2021, Your Lordships.
47.
Yes,
45 to 47, he does not do anything. Your DLSA, SLSA person. But in the additional affidavit filed at page 48,
48.
he encloses the order of 25 to 2020. Now, this is a case where the victim was has arisen on an application by alleging that the dead body of the father so and so has recovered. After registration and the statement made by the victim is stated that 9 years ago unknown culprit is there. On perusal of the so and so, it is found that so and so has acquitted the accused persons in absence of alia. There is no recommendation of the court determining victim compensation led to the as per so and so victim claim cannot be entertained after the date of the crime. However, realistic has confirmed the delayed citing reason. The occasion the alleged crime took place in India, but this investigation has been filed in March, which is after more than 10 years. Moreover, the session and right after the case of the same incident was also disposed of on in the petition, the petition has not cited in the reason for that. Thereupon, something to of the finance laws on account of the incident with financing. Again, there is no recommendation for victim compensation.
Lordship, the fact remains that he has not filed an appeal before the State Legal Service Authority assailing this particular order in terms of the scheme. Till date, he has not done that.
Let us see the scheme. Eligibility.
The scheme,
Scheme, my lord.
At page 21 of the,
Page 21, 4, 4,
no,
4, 4.
4, your lordships.
4, 4.
4, yes, your lordships. No, but then, your lordship, in terms of the DLSA has passed an order. Now at page 22, in terms of clause 8, there is an appeal provision. Once the DLSA has passed an order rejecting his claim, the immediate solution for his
Being the matter for pending for 6 years, would it be proper on the
lordship,
part
but
of
this
this court
affidavit
to?
was filed way back in 2021, your lordships. I have appeared only today, but this affidavit was brought on record in 2021, your lordships. So he has known that his appeal provision that he can easily file, he can challenge
But
that
would it
order.
be
Why has
proper
he
on the part of this court after 6 years to remand him, no, go and file an appeal?
lordship, the fact remains that if I'm not mistaken, the crime was committed in the year 2009. And he has come to the DLSA only in 2019 after a delay of 10 years. The DLSA in its own wisdom has passed an order saying that he's not entitled, the delay is not likely, it is not
Now,
condolable.
I have also passed an order that merely because the appeal, it will depend on many aspects. Earlier, I have passed an order to the effect as to when the application has to be filed in some period at 7. No claim made by the so and so under so and so act shall be entertained after the period from the date of occurrence of the crime. I say that this provision is not proper, taking into account that he may not. Tomorrow, if you are saying that this goes against 4-4,
Lord,
if a person is being acquitted, then also he gets a right. Yes, he has to explain the delay. That's a different thing.
lordship, so, the entire case was rejected on the ground of delay only.
No, you have rejected not on the ground of delay. You say that high court have not asked that they should be paid.
I do not have anything to say on
Your
this because
father.
it is the
Your father died.
Okay.
Who are you?
I'm son, my lord, elder son.
You are the son.
I am the son, my lord.
So are you entitled to
I'm entitled to, my lord.
victim compensation? Who is entitled? Are you a victim?
Because, my lord,
Let us see the definition of victim.
my lord.
Victim means the person who has suffered any loss or injury caused by reason of an act or omission for which the accused person had been charged. An expression victim includes his or her guardian or legal heir. So therefore, he is the victim.
Then, my lord, we had only two brothers, one sister, we were minor, my lord. And mother, my lord, after this incident, my lord, she is, my lord, mentally damaged, my lord.
Okay. What to do? Why you are making so many judgments here?
Well, so many judgments on delay also, my lord, there are some judgments on them. And in Opututtu case, my lord, Opututtu case and then Suresh versus State of Haryana. I have, my lord, annexed one judgment of this honorable court where all these
Oh.
cases are discussed, my lord. Therefore, I have annexed only one.
If the court makes a mistake of not passing that order, then a person be here. Anyways, we do one thing. We have it after vacation. It's this type of order.
Page 43, my lord, it's a similar order, my lord. I have. Page 43.
Was the repetition at any point of time disposed of? No.
No, man. Once, my lord, this honorable court, my lord, disposed of the matter. Once this honorable court, my lord, reserved the judgment, my lord, and then, my lord, again it was listed, my lord. Then, my lord, my lordship said that no, it should not be sent to the, my lord, state legal service authority because they will not do anything else. So you file one affidavit in additional affidavit or reply against their rejection because during, my lord, pendency of this writ petition they have rejected. Therefore, my lord, I have filed additional affidavit in terms of the order passed by this honorable.
Therefore, I see a draft of that. Hey, draft of the- We do one thing, we'll have it after vacation finish.
Well,
It's R.H. Chaudhary, the learned counsel who appears on behalf of the newly impleaded. You're newly impleaded.
Lordship, no, not newly impleted. I have been told to appear only just on the by way of the last
On
order.
behalf of the.
Respondent number two. Two.
Two submits that she has only entered into appearance today,
Yes, Your Lord.
and as such requires some more time. So, taking into account the above, lists matter on 24th of July 2026 for final disposal. So, in the meantime, respondent number two. In the meantime, the councils are that informed. I've put to notice that either they may file their additional pleadings if so required on or before 20th of July 2000.
well, obliged.
Deeply obliged.
Yes.
Lordship,
What is
My,
the matter about?
Lordship,
What is your matter about?
matter in this case is that, by filing this writ petition, have, challenged the orders passed by the learned tribunal, CGIT, dismissing our applications filed under section 33 C2 of the Industrial District Act 1947 that which we have filed, praying for computation of our areas and for recovery of the areas and
There is an award passed.
yes, affirmed by the Honorable Supreme Court.
Now that amount you have not got it.
Lordship, there are two issues that had been raised during trial. Is that during the pendency of the civil appeal for the Honorable Supreme Court, an MOU has been acted upon, by which an goodwill goodwill package was brought, and as per the terms of the MOU, we have taken part payment of under the goodwill package, and we have relinquished our rights and benefits that are supposed to be given to us as beneficiaries of the award. Now, accordingly, learned tribunal, based on the evidences and materials that has been placed by the respondent, supported documents thereof, dismissed our applications on the ground that these applications are not maintainable, and as we have signed an MOU and we have taken benefits under the goodwill package. So now, Lordships, we have challenged this.
So this order which has been passed, 2017.
Yeah.
Then order passed under 33C.
Yes.
Now these order have not been complied with.
Yes.
So you are before this court. Why should we entertain this type of?
On the ground that it is under the supervisory jurisdiction of this honorable court. This honorable court has a very limited power. Only this honorable court can take into account when the learned trial court or tribunal acted without jurisdiction or exceeded its limits or refused to exercise jurisdiction. In this connection,
Passed by the other court.
I have three grounds that I would like to place before your lordships. As per my submission, the learned tribunal has exceeded its jurisdiction. Now, the
So
learned.
you are challenging the order by which your application under 33C was rejected?
Yes. And stated to be not maintainable, that we have taken part of payment as benefits and relinquished our rights by signing some of the affidavits. And as per the terms of, as per the clause 8 and 9 of the said MOU.
So the report will be necessary.
Yes, record.
If the report comes.
No, Your Worship. Records are not,
Still,
records are necessary.
So you are challenging those orders passed by the tribunal. 1/6/2017.
Yes, two orders are there, 31/5/2017 and 1/6.
But why have you challenged up to 6 years?
We have filed the writ petition in the year 2017. This honorable court dismissed those that writ petition because that has been filed forming an union. As per your lordship's order, the union do not have locus standi, and applications, individual applications as has been filed before the tribunal, we should come before this honorable court by filing individual.
Where is that order?
Hundred.
300? Why pass that order?
€321.
So therefore you have filed these.
€322. But liberty was given if parties come in the.
So therefore we require the reports.
Yes.
Heard me sworn through the learned counsel appearing on behalf of the petitioner. Petitioner in the batch of petitions. And Sahiwala, the learned senior counsel. Said by Mr. P.K. Das for the wing the seat. The petitioners have assailed the orders dated 1/6/2017 passed in. Proceeding under section 33C of the Industrial Dispute Act 1947. And for the purpose of adjudication of the legality and validity of the orders dated 1/6/2017. It is the opinion of this court that the reports will be necessary. Accordingly, list this matter for final disposal on 15th of September 2026. In the meantime, the registry shall call for the reports of which case number?
4 miscases are there.
Huh?
4 miscases are here.
What?
'17, '18, '19, and '22 of 2013.
This case, na?
Yes,
Miss reference case, or this case?
miscases.
This case number 17 of this
17 of 2013,
2013. This case number 18 of 2013. This case number
19,
2013.
And
This case number 20 of
22.
22 of 20. 22 of 2013. From the
Lada CGIT, number 4.
from the court of the learned central government industrial tribunal.
Industrial Tribunal, Gauhati.
The registry shall do the take necessary steps. And by ensuring that the safe records are available, the next stage to fix the.
Much of.
Please, Lordship, the matter has become infractious, my lord. The relief sought for in this petition has got a relief, my lord.
The sworn through the learned counsel appearing on behalf of the petitioner submit that the petitioner has been granted the relief for which the instant petition required. Taking into account the above, nothing further revives in the instant petition for which the petition stands closed. Yes, what is it?
May I please, Lordship? My lord, here, my lord, the society was dissolved due to AGM could not be held on 24/9/23. But by the impugned order, my lord, the ARCS has directed that the nomination paper of 15 candidates are to be kept intact for the next election. By him, we cannot remember. That is the case, madam. This page 34 is the impugned order.
Now what is happening? As of now?
As of now, the one-man committee is running the society. So a one-man committee appointed from time to time, he will hold the election.
Yes. Who is appearing for the population department?
Lordship, I'm appearing in this matter, Your Lordship.
Understood, but tell me, 1/6 mandates a period of 90 days.
Yes, Your Lordship, that is true, Your
How are
Lordship.
you still running?
That is true, Your Lordship. Because of the Lordship, no elections has been conducted till now, Your Lordship, by the
Online.
department.
Online is appearing.
I'm thinking
Oh, yes, sorry. Sorry.
yes.
Lordship, otherwise the 90 days term has passed, Your Lordship, and no
So
elections.
we hold that authorized officer, the officer has no jurisdiction.
Otherwise,
You
Lordship,
cannot
the
run it for 3 years.
yes, Your Lordship, that is true, Your
Then
Lordship.
this is in complete violation for section 41(6).
Lordship.
You hold it
Lordship.
and then don't hold these directors who were there as disqualified and proceed with it within. 45
Lordship.
days.
My lord, I have appeared for some of the, my lord, respondents,
Who are
8, 9, 10, and my lord, 11, 15, 16, and 17. We are, my lord, the persons who had my lord, participated in the election, and we had submitted our nominations. We have no grievance that our nomination should be cancelled. But regarding the disqualification, my lord, whether we are disqualified, that issue should be decided, my lord.
That is why I'm saying they are not disqualified.
Not
It
disqualified.
is the mistake of the secretary.
Yes, my lord.
Secretary should be known.
Yes, my lord. We may be allowed to participate, my lord. Yes, that is.
Lordship.
You're also paying there.
Yes, my lord, we are also, my lord. But the thing is that my disqualification, my lord,
He is only agreed by my nomination, my lord.
that nomination, my lord, the ARCS.
There will be a fresh.
Yes, my lord. That can be.
The fresh nomination will be considered without considering that on account of not holding the election, they should not be held to disqualified. As it was the mistake of the secretary.
Yes.
My lord, secretary, my lord, since the election could not be held. So, my lord, therefore, that nomination which has been submitted or the board, earlier board, who are the members, they could not hold the election. So they're being disqualified as per that provision of section 40.
But it was a mistake of the secretary.
Yes.
That cannot be said. In any case, they are to hold election, my lord. They cannot blame now secretary.
Decided by the coordinate bench. That is. But that is. But separate that matter. If court held that not disqualified for the mistake of the secretary or the department. See, well, already there.
These judgment do not attract, my lord.
Same issue was there, my lord. Paragraph 13, my lord. The only difference in that, my lord, in that case, the term was not completed, my lord.
There was the term was not completed.
No,
No,
it get term
They
completed.
are to complete.
No, no,
they-
here the term would have completed on 7/10/2000.
2023, your lordship.
And the order was passed on 3/10/2020.
Yes, they are to hold
On the
election.
ground, they took attempts to hold the election, but there was lack of quorum.
Yes.
No, my lord. That is one point, my lord.
People cannot be disqualified.
That is one point, my lord. The other point is that they are to hold election prior to 309 30th September of the year. That is as per section 39.
So here he
That
categorically
is-
said that the board of directors of so and so is yet to complete the term of 5 years. He ended on 17.
Of course, in a year, as per section 39 says, while running the society, in a year, they are to hold, in any case, they are to hold meeting AGM prior to 30th September of that year, any year, every year. Man. So now adjournment can be done. Meeting held on 24/9. If any adjournment is taken place, it crosses the 30th September,
The election was held on, was scheduled on
24/9, 24/9.
However, on 24 was cancelled due to lack of quorum.
Ne-
And adjournment was not possible since next day falls on the month of October.
Yes, adjournment was possible because it passes 30th September.
Otherwise, the mandate of the particular rule also say, the act or rule categorically says that it would be held only the next week, earliest.
Yes.
Yes, yes.
Yes, yes. sir.
Earliest by next week. So 24th, the next week will be 31st. 31st.
First October.
First September is not there.
Yes.
It will be the 1st of October. So if it is the 1st of October, it is outside. So it is not the mistake. So you want what? They should not participate.
No, because they have become disqualified from filing nomination because they could not hold the AGM prior to
So
30th
you are
September.
against the board members cannot be termed disqualified. Against that you are here.
Yes, madam, they are disqualified.
Where is the disqualification?
Yes, madam.
When 42 AML.
My lord, 39, section 39 may kindly be seen, madam. Section 39. A general meeting to be termed as annual general assembly of a registered cooperative society shall be held at least once in every cooperative year within a period 6 months of close of financial year to transact the business as provided in this act. The board shall automatically stand dissolved for not holding annual general meeting.
40, madam. Section 40, subsection 4A.
4A.
Subject to such the conditions that will be specified in the bylaws, a member of the cooperative society will be included as. That member has been 5 years. Okay, so we do one thing. We have the problem with 34. They have it after 2 years, this matter. 5 years will be over.
Well, that is the intention of the petitioners. They are sole holders. Just before 2 days, they have
my lord, obtained an order from this honorable court, my lord, 3 years back. Their intention is just to, my lord, defeat the democratic process. And my lord, there was no stay of the election, my lord. The 3 years, no election is held. The stay was only regarding, my lord, this part, my lord. Their nomination should not be considered. Even then, my election is not held. So, my lord, if it is, my lord, granted, then there will be, my lord, there is their intention, my lord, of filing this petition, my lord. Only to in nexus. Who are you? My lord, we are the, my lord, they are the shareholder. They did not participate in the election.
So what is your intention? There should be
The election should be there and new, the nomination should be filed. And since the earlier board could not hold the AGM in time, so they have automatically disqualified
Let us
themselves.
see why the earlier board was dissolved, meeting could not be held. Where is the minutes of those meetings?
Page number 27.
And that's 5. Since they could not hold AGM, so they have cancelled the proceeding. AGM election, they have cancelled.
This mentioned when AGM was held, my lord. And regarding held, convene all that, my lord, discussed in the, my lord, judgment I have provided, my lord, of this quarter. This issue is, my lord, decided.
Their judgment is applied, not applied because the 30th September comes in the way.
It is decided, my lord, this issue.
Here, adjournment could be done, 30th September do not come in the way.
My lord, paragraph 13 onward, my lord, 13, 14 and 15. Can it, my lord, from 11, my lord, paragraph number 11. Apparently, in the communication date 14/7/20, the Assistant Registrar Cooperative Society had invoked power 41(4) and 41(6) to declare the board directors no locus standi after expiry of 5 years of its terms and to appoint one officer of cooperation department to be in charge. We have examined the matter detailed and also heard the learned concerns. Apparently, the provision of 14(4) and 14(6) are applicable when a board of directors had failed to arrange for holding of election before expiry of the term of their office in accordance with the Act and the bylaws. The
So you
condition.
mean to say, the judgment say,
May I read, my lord, the
so the judgment say, this will not be a case of alia, but it will be a case of a disqualification in terms of 44C. 44C, David 41(4). Isn't it?
Well,
You don't have the book.
yes, ma'am. 41.
In the case of 44C, David 41(4).
Yes, ma'am.
And if that be so, that disqualification would only happen where the board fails to arrange for holding the election.
Elections.
Yes.
And as we both tried, but there was.
Yes.
Tomorrow.
Yes. Yes, madam. In this case, we have tried, my lord, and
We allow his petition partly make that the election should be held and partly we allow that we should not be. Out with the DC, not the Lilith Council appearing. Makes the.
Lordship, for respond number 1 to 4, your lordship.
On behalf of the respective 1, 2, 3. You are paying for 5
my
and
lord,
6.
8, 9, 10.
Where you are, where is it?
Private respondent.
My lord, subsequently, my lord,
Subsequently amended.
Mr. Swain,
Absolutely,
so
my
you are
lord.
on behalf of the- 8, 9, and 10.
Yeah, 11, 15, 16, 17.
Okay, we are for the prime investment. Who appears for 5 and 6?
I think since now no board is there. One man committee. is
One
there.
man committee, sir.
The instant requisition has been filed challenging the order dated P-10/2023 passed by the Assistant Register of the Cooperative Society, Kachar Silchar, who is the respondent number 4 in the present proceedings. The brief facts which led to the filing of the present proceeding are that the petitioners herein are shareholder of a cooperative society in the name and style of Sonabari Ghat GPSS Limited. There was a requirement of holding the AGM of the elections of the said cooperative society on or before 30/9/2023. The said however, though the elections were called for, AGM of the election was called for by the notice dated
Page number 23.
14/9.
1st of September 2020.
on 1st of September 2023. 39/2020. The board of directors in the meeting held on 28/2023 resolved amongst other that the AGM in election would be held on 24/9/2023 at Udo Hari Musafir High School. And the secretary of the said cooperative society was directed to do the needful as per the rules. In pursuance thereto, notices were issued for holding the AGM as well as the elections therein. The respondent number 4 had also issued an order on 8th of September 2023, fixing the date of nomination, including venue fixed by the society as per the proceeding, and the date of election, including venue fixed by the society as per proceedings. The date of nomination was
14/9.
on 14/9/2023, and the date of election was on 24/9/2023. 24/9. It may not be out of place at this stage to mention that a said cooperative society, the cooperative society may not be out of place to mention that the total shareholding of the said cooperative society is 3065 members. And there was therefore a requirement in terms with section 30, 34. 34. Of the Assam Cooperative Societies Act 2007, or short, the Act of 2007. That there should be at least 10% of the shareholders present to constitute the quorum. However, on the date and time so fixed for holding the elections, AGM oblique election, only 123 members, shareholders were present. And as such, there was not an adequate quorum. In the
34-2, Your Lordship.
34-1. 1. 2 is for adjournment for 1 year.
34-2. Subsection 1 and 2 of section 34 of the Act of 2007. Resultantly, in view of section 34-2 of the Act of 2007, the adjourned meeting cannot be held prior to seven days. Inasmuch as the language so employed in section 34-2 of the Act of 2007 is that the meeting shall be adjourned ordinarily to the same day in the next day, at the same time and place. Additionally, the discretion which is otherwise available to the chairman of the meeting was only to the extent of enlarging the said period of 7 days to a period not exceeding 15 days. Under such circumstances, the AGM oblique the election could not have been held on or before 30/9/2023. It is under such circumstances, in terms with section 39 of the Act of 2007, the respondent number 4 passed the impugn order dated 3/10/2023, whereby not only dissolved the board, not only dissolved the board, but also whereby in terms with section 39 of the Act of 2003, confirmed the dissolution of the board on account of not holding the elections within 13/9/2023, and further directed appointment of a one-man committee in terms with section 41(6) of the Act of 2007. The petitioner in that respect is not aggrieved. However, the grievance of the petitioner lies on the aspect where the respondent number 4 have observed in the impugned order that the board of members cannot be termed disqualified as the board members, board of directors could not complete the procedure within the month of September due to incompetence and malafide intention of the secretary. In the backdrop of the above, this court also heard Mr. B. Sinha, the learned counsel, appearing on behalf of the petitioner, who submitted that as the elections could not be, or AGM of the elections could not be held on or before 35/9/2023. By virtue of section 44A, 40(4)(a) of the Act of 2013 and 7, the directors of the existing board which stood dissolved are disqualified to participate for a period of 5 years. And this statutory injunction incorporated in section 40 of the Act of 2007 was totally disregarded by the respondent number 4 in passing the impugned order. Per contra, Mr. M.J. Kadir, the learned counsel who appears on behalf of the private respondents, submitted that it is not a case wherein section 40A of the Act of 2007 would be applicable. It is a case at best coming within the ambit of section 44C, read with section 41(4) of the Act of 2007. The learned counsel submitted that section 41(4), that the tenor of the impugned order would categorically show that the dissolution was on account of holding the meeting in terms with section 39. But as there were arrangements made to hold the election by the board of directors in the resolution adopted on 28/2023, and further directions being issued to the secretary to take effective steps, and in pursuance thereto, the meeting was AGM oblique the AGM in pursuance thereto, steps were taken for holding the elections, and AGM oblique elections were held on 24/9/2023, but could not be completed on account of lack of quorum. It would be a case wherein it would not be a case wherein the private respondents who are the board of directors would be disqualified. The learned counsel appearing on behalf of the respondent further submitted that clause C of section 2C4 was inserted by the amendment made to the Act of 2007 with effect from 28/5/2019. And therefore, this amendment, the legislature had carefully taken into consideration that wherein arrangements were made for holding the elections, the directors of the board cannot be disqualified. In that regard, the learned counsel submitted that the issue involved in the instant proceedings is also covered by the judgment of the learned bench of this court in the case of Uttar Rani Khanda Unity Unorganized Committee Limited versus the state of Assam and four others reported in 2020 DAU-AS 7393 and specifically referred to paragraph number 13 of the said judgment. This would have given an anxious consideration. Yes, Mr. G. Bogdoy,
Lordship,
you are in the luxury out there in your AC. Tell me, what do you have to say?
Lordship, otherwise, your Lordship, the impugn order has been passed and they could have preferred an appeal before the Register of Cooperative Societies. Now, instead of that, they,
You have to speak slowly.
Lordship, they could have preferred an appeal challenging the issue before the Registrar also, your Lordship, but they have preferred the writ petition. And Lordship, it is a fact that your Lordship,
Yes,
and
the
your
most important part is missing on merits. What do you have to say?
Lordship, on merits, your Lordship, we have failed to conduct the election even after passing of 90 days, your Lordship. That is true, your Lordship. Because one man.
No, that is a different thing.
Lordship.
On merits, what do you have to say?
Merits,
On the
your
point
Lordship.
whether they will be disqualified.
Lordship, I think with my limited knowledge, your Lordship, they shall not be disqualified, your Lordship.
Mr. G. Bordloy, the learned counsel appearing on behalf of the Corporation Department, supporting the order dated 3/10/2023, submits that the petitioner ought to have had an alternative and efficacious remedy by preparing an appeal before the Register Cooperative Society of Cooperative Societies. The learned counsel further submitted that as per the submitted that from the fact on merits, the impugn order dated 3/10/2023 cannot be said to be contrary to the provisions of the Act of 2007. In as much as few arrangements were made for the purpose of holding the AGM of the elections, and therefore the respondents herein, the private respondents herein who were the board of directors could not be held to be disqualified. The learned counsel further submitted that section 44A would only come in a case where elections have not been conducted or wrong where AGM, where AGMs have not been conducted or wrongly conducted. But in the instant case, the elections, the AGM of the elections was duly conducted. However, on account of lack of quorum, the said meeting could not be held. This court had given an anxious consideration to the respective submissions and had perused the materials in the court. From a perusal of the materials in the court, it is apparent that there was an attempt made for holding the elections on 24 AGM of the election on 24/9/2023. This aspect is apparent from a perusal of the resolution adopted by the Board of Directors on 28/2023, whereby the date as well as the venue for holding the elections were fixed. This resolution of the board was thereupon, of the Board of Directors of the Cooperative Society thereupon, was forwarded to the respondent number 4. And this very aspect would be apparent from the order of the respondent number 4, dated 8th of September 2023, whereby the returning officer, the assistant returning officer, were duly appointed and the elections, AGM as well as the elections were duly notified, including the date of submission of the nomination. The records further reveal that on the appointed date and time, the election, the AGM was held, was organized. However, on the same date, the elections, the AGM could not be proceeded with on account of the lack of quorum, which is otherwise mandated under Section 34(1) of the Act of 2007. It may not, it is also pertinent at this stage to take note of that the elections were, that in terms with Section 34(2) of the Act of 2007, there cannot be a AGM, the AGM of the elections which were supposed to be held on 24/9/2023 could not have been deferred to a date within 13/9/2023, as it is the mandate to have this mandate, the mandate that the said meeting mandate of Section 34(2) of the Act of 2007, that a meeting would be held on the next week on the same venue and same date. Under such circumstances, It is therefore the opinion of the court that this is not a case where coming within the ambit of not conducting or wrongly conducting the annual general meeting under section 39 or special general meeting under subsection 3 of section 33 and the board meeting under subsection 3 of section 43. Rather, it is done within the ambit of subsection C, clause C of section 444. Within the ambit of clause C of section 444 of not conducting the meeting of the board under subsection 4 of section 41, provided no steps were taken to arrange for holding of the meeting. Yes. However, in the instant case, as steps were duly taken for holding of the AGM, as aforesaid noted, the board of directors, the members of the board, the directors, the members, the board of directors of the cooperative society cannot be held to be disqualified in terms of section 40 C. Redwick, section 41(4) of the Act of 2007. The said opinion of the court is supported by the judgment of the learned coordinate bench of this court in the case of Uttar Bharati Akanda Bahumukhi Samavai Samiti Limited, Supra, and more particularly to the observations made at paragraph number 13 and 14 13, 14, and 15. At paragraph number 13 of the said judgment which is reproduced here in under. In that view of the matter, this court does not find any infirmity in the order dated 3/10/2023, which have been impugned in the instant proceeding. Next. It, however, surprises this court, take note of, that in terms with section 41(6) of the Act of 2007, the period, the permissible period within which the executive officer can conduct the affairs of the cooperative society is limited to 90 days. This period of 90 days is being granted to the executive officer of the cooperative society, so appointed for the cooperative society in order to take appropriate steps for holding the elections. It shocks and surprises this court that even after a passage of more than 2.5 years, no steps in that regard have been taken by the Corporation Department, inasmuch as it has been informed to this court during the course of the hearing that the state executive officer appointed by the order dated 3/10/2023 is still controlling the affairs of the cooperative society. in the opinion of this court, that the said aspect is in negation of the democratic principles behind the running of the cooperative society. Accordingly, the instant petition stands disposed of with the following observations and directions. This court, for the reasons aforesaid, number one, is for the reasons aforesaid, is not inclined to interfere with the order dated 3/10/2023. Number two, the board of directors of the cooperative society who were there in the management prior to the dissolution on 3/10/2020 by the impugned order dated 3/10/2023 shall not be subject to disqualification in terms with section 44 of the Act of 2023-2007. However, they may be subject to the other disqualification as permissible under the Act of 2007. The respondent, the registered cooperative society, is directed forthwith to take effective steps for holding the AGM oblique the elections of the cooperative society, and the same should not be later than 60 days
Lordship.
from the date of the present judgment. Mr. G. Bordloy, who appears on behalf of the Corporation Department, shall duly intimate the registered cooperative societies, Government of Assam, to do the needful as per the directions given by the court.
Lordship.
Right.
Obliged.
Your Lordship, the conducting counsel of this matter is not available in court, Your Lordship, because due to some medical emergency, he went to the hospital, Your Lordship.
We are paying for?
Yes, no, for you. Without the land,
Who is the owner?
principal development officer.
We don't find any ground for it. In fact, the order is completely wrong.
further say that action can be only taken where is my judgment. That appears on behalf of the revenue. The issue may appear from the community. The appears from it. The present petition has been filed extending the order date is judgment and order dated 3/2023 passed by the learned Assam Board of Revenue. Gauhati. The learned Assam Board of Revenue. Whereby the order passed by the order dated 4/9/2020, 2002 passed by the learned additional date. Deputy Commissioner in PRS case number 94 of 2002 was set aside with a fresh direction to the learned Deputy Commissioner for disposal afresh as per the applicable laws and rules. This court has duly perused the order dated 6/9/2022, which have been passed by the learned deputy, by the additional Deputy Commissioner, Revenue Principal. And in the opinion of this court, that said order is totally misconceived in as much as merely because of the fact that the record holder, the settlement holder, the landholder, is that the proprietor or the landholder is not in possession of the land in question. Resort to Rule 116 of the settlement rules framed under the Assam Land and Revenue Regulation 1886 is not permissible. In that regard, this court finds it relevant to take note of the judgment of the learned coordinate bench of this court in the case of Bhavani Sankar Bagaria versus State of Assam and others reported in 2008 code GLR 134. And the same opinions and the same view having been reiterated by this court in various judgments, including in the case of MS Maudi and Seed Company Limited versus State of Assam, reported in so and so reported news. Additionally, this court also takes note of the reasons so assigned by the learned Assam Board of Revenue, wherein the learned Assam Board of Revenue categorically held that the additional Deputy Commissioner Revenue have passed the order dated 6/9/2022 without serving notice upon the record holder land upon the respondent number 4, who was the appellant before the learned Assam Board of Revenue, and also found
that the application so filed by the petitioner herein where the respondents in the proceedings before the learned Assam Board of Revenue were defective. The learned Assam Board of Revenue further set aside the order dated, have further rightly set aside the order dated 4969/2022 passed by the additional Deputy Commissioner Tinsukia in PR case number 94/2002 and remanded the matter back to the District Commissioner Tinsukia for disposal afresh as per the applicable laws and rules. Considering the above, this court does not find any infirmity in the order dated, in the judgment and order dated 3/6/2023 passed in case number 26 RA bracket TIN/2018, for which the impugned order, for which the instant writ petition is being meritless, stands dismissed. Before parting with the record, this court, however, finds it very pertinent to observe that though the learned Assam Board of Revenue had remanded the matter back to the District Commissioner in Sukia for deciding afresh, the learned, the District Commissioner Tinsukia or the additional District Commissioner Tinsukia shall decide the same by taking note of the judgment of this court in the case of Bhavani Sankar Bagaria Supra, and more particularly to paragraph number 5, which is reproduced here in under.
May please.
What did it I with this?
My lord, I for my lord, impeachment of my lord railway official, as party of.
Whom do you want? A for impleading whom?
My lord, railway officials. That's opposite party number 528.
Why? Why do you want the railways?
My lord, lordship will find page 30, my lord, of the writ petition. My lord.
Why?
My lord, because I am possessing the railway land, my lord. My lord possesses the certificate issued by the circle officer, wherein it has been reflected that, my lord.
What is the matter about?
Eviction, my lord.
Under? Why?
While my lord circle officer issued notice to me, my lord. That I have said.
So you want to be, again, you will be in much bigger problem, do you understand? The circle officer, you keep on filing cases after cases, you can be, they will have something else. Representation and all these things.
Yes, my lord.
But the moment you say that you are in a railway lane and unauthorized, they will immediately initiate section 5. Don't you think that you will be more bigger trouble? Huh? Let's see your bin case. What is that case?
My lord, writ petition, my lord. Page 35 is the, my lord, review notice.
35. Have you submitted your reply?
Yes, my lord, I have filed, my lord, that page 37.
37.
37.
Okay. Very well, they have now considered the reply. With that, don't press there. You'll be in bigger trouble. Don't do that. We allow them. We say that, okay, let them decide and look into it. giving you further liberty to approach appropriate forum, including this court, if any steps are being taken by them. You take it up there, but if I make it with your admission as railway line out here, then tomorrow they will go to section 5. Unless they have authorized you. Have they authorized you, railways?
Yes, sir.
Where is that?
That lordship will find page 29.
Page 29 of
Repetition.
the writ petition. Where? There's no dark number?
My lord, there is no tag number, but boundary has been mentioned, my lord. In the subsequent, my lord, page 30, my lord.
Okay. This document, are you denying this document?
Apparently no, lordship.
No, this document has page 30.
Yes, lordship. Otherwise it is signed by the circle officer, but I do not have any instruction, but this document is on oath, lordship, yes, my understanding.
So if that be so, they cannot take any action. Why do we need the railway?
Yes.
You take note of this while passing an order.
Yes, yes, lordship.
Take
Disposing of this
note of this.
reply, lordship.
And certify that on the use, and this is being said the government dark number so and so, and railway certified the existence of area on the unused plot of land since 1997. So if this is the document out here that it is railway land, you cannot initiate section 18.
But, okay, that is true, lordship, but according to him, he is occupying 4 kata 9 lessons under the tag number 119. That this notice will trigger to 1 kata 15 lessons.
Page 30 certificate also 4 kata 9 lesson.
Whether this is within that railway land or beyond that, lordship.
Railway has given you to occupy 4 kata 9 liters. One bigger. What do you hold? You see, that's
10 measuring 16 feet into 120.
Huh?
Lot of measuring 60 into 120. 120 feet.
square feet. Square feet would be how much?
144 is equal to 1 lesser.
72.
147,000 square feet, 1 lesser.
Liters. 50 liters will be how much?
2 kata 10.
2 kata 10 liters.
2 kotas 10 lesser.
Then if that is so, then
So he is occupying 4
why
kotas,
is he given 4 kata 9 liters?
9 lessers. So beyond that, most
We
probably
meet
it
the
may be a-
railways a party. Is an application filed for impleading. The opposite party number 5 to 8 in the instance of the 5 to 8 as party to the accompanying writ petition on the ground that the land in question wherein the petitioner is presently under occupation belongs to the railway land. So taking into account, so this court also takes note of Annexure 2 to the writ petition, wherein it is seen that the railway, who has certified this?
My lord, this is my lord in charge of construction.
Huh?
In charge of construction.
Huh? How can in charge of construction certify that?
I am not sure, my lord, but
Which is a certificate issued by some railway authority, some purported railway authority, stating that the petitioner association petitioner institution is occupying an unused railway plot of land in the area of North Bongaigaon at measuring 16 to 120 feet. It is very pertinent to observe that the area so mentioned in Annexure 3 would be an area approximately 2 katha 10 acres. However, a perusal of Annexure 4 reveals that the circle officer Bongaigaon Revenue Circle have certified that the railway have permitted the petitioner to use 4 katha 9 acres of land. It is not understood on what basis such certificate have been issued. Taking into account these aspects, it is the opinion of this court that the presence of the opposite party number 5 to 8 are required for a proper adjudication of the present writ petition of the accompanying writ petition. Accordingly, the opposite party number 5 to 8 in the instant proceedings are arrayed as respondent numbers 5 to 8 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties within 3 days, by Monday, before the registry of this court, and the registry shall, on the basis thereof, make necessary correction in the post title and update the same in the CIS. Main case. Ms. Agayon accepts notice on behalf, issue notice upon the newly impleaded respondent number 5 to 8. Ms. Agayon, the learned CDC, accepts notice on behalf of the respondent number 5 to 8. Extra copies of the writ petition be served upon her by Monday. It is the opinion of this court that the affidavit on behalf of the circle officer, Bongaigaon Revenue Circle, as well as an affidavit on behalf of the divisional railway manager. No? Who will be competent to say about this thing? Divisional railway manager, Longya division. Who is the respondent number 7 to the in the instant writ petition? Respondent number. Who are the respondent numbers? Four and 7 in the respectively in the instant writ petition would be required for an effective adjudication of the present proceedings. The said affidavits be filed without fail on or before 22nd of July 2026. List this matter again on 31st of July 2026. Liberty given to the petitioner to file any reply thereagainst. Interim order passed earlier shall continue till the next date.
In this matter, today morning, I have received an affidavit filed by respondent number 6 and 7, Lordship. But I am not in the record. I am appearing on behalf of ADAS. I am appearing on behalf of ADAS, Lordship.
ADAS?
Yes, sir.
The petitioner is challenging the shifting rejection, Lordship. Challenging the shifting rejection. He wanted to shift the shop from one place to another place, and that was rejected.
Rural?
Rural.
You allowed it.
Now, further, there's an amendment. Recently, there's an amendment here,
But
Lordship.
then also only in Gauhati they is not permissible.
No, there's a distance between two shop. Now they have inserted a new rule. Distance between two shop has been inserted.
500 meters.
In Kamru 500 meters, in rural 2 kilometers.
Kilometers, you'll find it out.
They have submitted the application. They have to submit the application for shifting in another place, Your Lordship, because there's already an off shop located within this 105 meters.
So let them file it from other place.
They can do that.
We do one thing.
Chief, today morning I have received an affidavit filed by respondent number 6 and 7, Lordship.
So what? What does it matter?
Not to actually, I am not engaged on this methodology. Just now I am instructed by ADAS that kindly admit its method, Lordship. Actually, I have no
Who
knowledge.
appeared? Okay.
ADAS, Namika Das.
No, he's not here. He no, there's no name. You have been instructed by somebody whose name in no way appears anywhere. He's not a person who has signed Wakalatama.
Lordship. ADAS is here, Lordship. Last one, Lordship.
Name is not there. What about the other people? R. Pukon.
Actually, I have no knowledge. Kindly agenda matter for today, Lordship.
Oh no, this matter doesn't happen like this in my court. Philip. The counsel appearing on behalf of the petitioner will not seem to be interested in a quick disposal. List this matter on 18th of January 2027.
Your Lordship, on last occasion, my lord has instructed the body.
Ah,
Chairman is A, we. Chairman A.
okay, Chairman, I told you, na, these people are there.
Submitted.
We cannot have it like this.
Point number 2, madam.
The board is representing the authority of the bank. Akas Ali Mir, chairman, by this letter resigned from the post of the chairman. His application for review was placed before, but the same are kept pending for consideration. Managing the hearing, no.
Chairman is there.
Huh?
Chairman is there, madam.
Chairman is there.
Your Lordship, in this matter, I filed my rejoinder on Monday, Your Lordship, but the same was not taken on record, so I cannot serve, I could not serve the respondent number 2, Your Lordship.
Who is responsible number two?
The bank, Your Lordship. Why? Because they, no one is there, we went to the bank also, bank didn't accept it. Your Lordship. The rejoinder. That's why it is lying in defect.
No, they are not represented anywhere. Now it is not there. So you have to now change it. The response number 2 does not exist in this manner. Earlier, it was represented by the administrator. Now they have a chairman, they have a board. So you have to get hold of that board.
Yeah, I find it.
Or Miss MD Bora, the learned standing counsel for the corporation department, had in pursuance to the order passed by this court on 12/6/2026, informed this court that pursuant to the elections held, the board of the respondent number 2 bank represents the bank. The administrator no longer represents the respondent number 2. She further submitted that one Sri Abbas Ali Mir was appointed as the chairman of the said bank. However, he had resigned on 21/5/2026 from the post of the chairmanship, and his application for resignation was placed before the board on 27/5/2026. Consequently, it is therefore the opinion of the court that the petitioner needs to take appropriate steps in the proceedings. Which the matter of such corrective measures were taken by.
Lordship, kindly keep mentioning part of the report. That instruction will be kindly given part of the report.
The instructions for placed is kept on record and marked the letter X. What is this IA business?
My lord, the brief has been misplaced, so we would not serve the copy. Brief have been misplaced, lordship.
Who's brief? Who is filing for this IA? Oh, this IA has been disposed of. Now, what is this case?
They've been included as a party in this case, but they were directed to furnish us the reputation copy.
Have the notice been issued pursuant to this?
No,
So notice has been issued upon the response number 5. Who is paying for response number 5?
I'm for responding.
Okay, what do you have to say?
We were directed to be furnished a copy, but they have not furnished us a copy. On as per the earlier order 29/2025, they were directed to furnish the copy to us.
You filed the application.
We have filed the application.
You must be having a copy of the petition.
No, we don't have the petition's copy.
Oh, then you should wait. Why did you approach this court by filing the IA?
We have this instruction that with the party.
And you don't have the file, no? Is there any stay? No stay. It is seen that the counsel appearing on behalf of the petitioner submits that the petitioner, the learned counsel does not have the file, has misplaced the file. It is also submitted by the respondent number counsel for the respondent number 5 that though there was a direction passed as far back as on 2/9/2025 to furnish a copy of the petition to the petitioner, the same have not been provided. Considering the above, it does not appear that the petitioner is serious with the instant proceedings. Accordingly, the writ petition stands adjourned sine die and shall only be listed upon service of copy of the writ petition to the counsel for the respondent number 5 and producing a receipt thereof before the registry with an application to the effect that the petitioner is willing to do the matter. The matter will come after 10 years. Contempt. What has happened? The contempt by admission? Anything for admission for contempt? What is this contempt admission? Why? What has happened? What is the matter about?
Regarding registration of the petitioners under the Assam Affirmative Council.
And
Because of some election, the council was not there. Now it has been formed. I've already intimated the new council member. Probably they will be looking into the issue. Can it be after the vacation? By that time, their registration applications will be considered. So they are not party here. They will look into the issue.
Only one thing you will see. In this case, the Honorable High Court's order is as old as December 2023. Thereafter, the main respondents are respondent number 1 and 2.
what did you ask, Mr. Gurabhai?
My Lord, your Lordship, kindly go to page 25. Page 25. That is the order. Para A. Para A. Simple direction from the Honorable Court to consider the applications of the petitioners to be entered their name in the first register of the premises so that they can practice as a
There's an application filed for alleging willful and deliberate violation to the order dated 5/12/2023, passed in deputation number 5564 of the 2023. The learned court made bench of this court by the order dated judgment in order dated 5/12/2023 disposed of the petition, thereby directing that upon the constitution of the interim state pharmacy council, the applications of the petitioner may be taken up for consideration. It is the council appearing on behalf of the petitioner, the senior council appearing on behalf of the petitioner, submitted that till date no steps in that regard have been taken. However, Mr. B. Gogoi, the learned counsel who represents the respondent number 1, submits that in the meantime, the State Pharmacy Council has been constituted and they will be duly taking into consideration, take steps for consideration of the applications so submitted by the petitioner. He therefore submits that some more time may be granted in that regard. This matter on 3rd of August 2026, on which date Mr. P. Gogoi, the learned counsel appearing on behalf of the respondent number 1, shall apprise this court as to what is the status as regards the consideration of the applications of the petitioners. What is this?
State has the right to file their affidavit today also. The matter with respect to the demarcation act also. What? It is the allegation of the petitioner that while constructing a PWD road, the responding authorities has encroached upon the land of the petitioner and acquired the land by constructing the state road over the land belonging to petitionership without following due process of law. So as such, he has requested the responding authorities to conduct a demarcation so to assess whether this land has been acquired and if yes, what is the quantity of land that has been acquired. But
why you are not doing it?
I got the inspection on 19th. I will file my, they have denied it by the, we have enforced the land by the.
Okay, well, they are asking for verification and demarcation, we can complete it.
I got the, I will file my affidavit.
No, you say that you have not enforced. They say that you have enforced. What is the best way? Carry out the demarcation. I think out here by filing pleadings not have any impact. Give a report as, no, I say a person order now that give to submit a report before this court by carrying out where is this land? Oh God, so circle of that? Ulubari. Ulubari, that is number 3, shall submit a report after carrying out the verification as to whether while constructing the road, there is any land, whether any part of the land encroaches upon the land of the petitioner. And matter Urge Mr. A. I, Ali, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi, the learned additional advocate general, appears on behalf of the respondent number 2, 3, 4, 5, 6. We are on the appeal for respondent number 1. The present petition has been filed by the petitioner, being aggrieved that the respondent PWD authorities, while constructing the road, have encroached upon the land belonging to the petitioner, which is specifically mentioned in annexure as Schedule A and Schedule B, the petition. The question as to whether there has been an encroachment or not has to be based upon a report by the revenue authorities. Under such circumstances, this court in the interim directs the respondent number 3 to carry out a verification in presence of an authorized official of the petitioner and submit a report before this court as to whether, while constructing the road by the PWD authorities, whether the road encroaches upon the land mentioned described in Schedule A and Schedule B to the petition. In addition to that, the report be also submitted by the respondent number 3 as to whether the land described in Schedule A and Schedule B are lands belonging to the petitioner. The said report be submitted before this court by way of an affidavit to be filed by the respondent number 3. List this matter on 9th of September 2026. Mr. Before you get this thing done, don't take time. Ask them to carry it out. Once it is done, matter will go. Yes, what is this?
My lord has heard this matter.
I heard this matter, then you were nowhere to be seen many times from your ground, your news have been taken.
Actually, there was a treatment in the family over this. My lord, what had happened here on the last 4/12/2025? Paragraph number 3.
But anyway, this matter can't be taken up like this. We'll have it after vacation. When? Actually, this matter was kept for final disposal on 2026. What are you looking at? I'm not asking you, I'm asking him.
Well, he need to be before 27th, my lord. I am shifting from Assam on and
So then no problem. Very good. Then there will be another council appearing, so we can fix the date. Let's have it after vacation.
Kindly fix it after vacation. Fix it, maybe give it. Okay.
So if you are leaving on 27th of July.
Yes.
July. Good. Then they will have it after vacation. There will be some other council representing the. You won't be. No. Because it will be difficult once it is fixed, then there is no person who will not there. I make a. So you are not taking, you are leaving Gauhati, but you are taking the practice. Taking into account that the petition has to be taken up for final disposal and it take some time, this matter on 18th of August 2026. Much of it.
This is an NIB issue for off license, liquor shop in Tinsukia.
What shop?
My lord,
What shop?
the off license shop for liquor bag. This is Virat. So I'm one of the bidder. My bid was 45 lakhs approximately. The private respondent number, bid was 10 lakhs. But we did not receive.
Your was 45
lakhs.
and
They
they
had
had
10 lakhs.
10 lakh. Okay.
Now we did not reach the
there should be. My bid was rejected on the ground that there was a requirement that the site plan had to be signed by an engineer. Did not specify whether it was electrical engineer or civil engineer or what it is. This kind of ambiguous, but we nevertheless, your lordship will find at page 173 is the site plan submitted by us. And below on the right hand side, your lordship will find this arc paradigm, architect, engineer, and interior designer. It was a team comprising of architect, engineers, and interior designer, but it was signed by the architect because he was the managing partner. So on that ground, that it was not signed by an engineer. That is the ground. That is the ground. It was
You are giving me a 10 lakh process. We don't know it because we have not opened this financial system. Because this technical is no, but it's a
My lord, what has happened? The respondent number 6 did not comply with, he also did not comply with the requirements of the.
I need some big 53. Site plan 35 by new. Give me a best inquiry whether it is
Page 171, 170. At the top line. This is number 1. I'm in number 2.
Here is either the site plan submitted is not certified by which is in the original. Whether the original contains the seal of the seal.
With architect.
Here, be an engineer.
We have the architects and
Whether Subham
he is an architect.
no.
Coming beyond that, what the respondent number 6 has done, they have not
They
submitted.
have categorically said engineer. Any engineer will do. He is not engineer, all right?
And no, my lord, what has happened, respondent number 6 has not, he has also not filed any kind of requirement. The main requirement was filing a form C. The form C was also not filed by the private sponsor. Now, what has happened in the affidavit by the additional deputy commissioner, who is a part of who's heading the selection committee, they say that form C was not submitted by eBay, but it was submitted in hard copy. Who? Respondent number 6. They have not submitted the papers through eBay, but the additional deputy commissioner in this affidavit says that it was submitted to us by hard copy. And form C is a very mandatory requirement to be filed. And
But even why should we consider this?
no, my lord, he's also an ineligible bidder because he has not filed his form C. Form C is a mandatory requirement. What they have done to the back door.
Form P, what is this form P?
Form C is a compilation, my lord, that is page 50.
Page 50.
My lord. Annexes. The form C they have not filed.
C.
Yes.
Checklist of bidders. But the checklist is not there.
Not there. So that is a mandatory requirement for filing of the NIP.
Where is
Madam, it is there, madam. It's
Where? Where?
not there.
Then,
Form C.
what? Say, where is it dependent?
Madam, form C is a mandatory requirement and
We make it
and no, madam, I'm not finished.
And actually, page 364.
This is to be given out the
Page 364, annexure 8, my lord.
that
8,
page 53.
364.
Yeah. For the technical bill.
My lord. In other cases, in other districts, whoever has not filed the Form C, their bids were rejected.
Where the bidder, the excise department, what you say? You mentioned it. You mentioned it also.
Otherwise, the private authority will file for. You know how they file. They have not filed for EPD. Behind the back,
Now, how is it possible, EBD, tell me, how is it possible for official use sign has to be there? Somebody has to sign officially.
no, Malik, it is not in the EB. That is what they are on the affidavit, they have said, the additional deputy commissioner said that you have received only the hard copy. Now, Madam, may kindly come to.
That is why your architect has given this, why you
No, Madam, may come to page.
anyway, in taking into account that.
Page 79.
Excise policy, you are better off.
No, my lord, page 79. At page 79, my lord. It starts at page 78. Page 78, preparation and submission of bids in a two cover bid. Now, below, at 79, what it says, in the event of discrepancy between online and hard copy of technical bid, the online bid shall prevail and shall be considered for evaluation. So, in the e-bidding system, in the online bid, they have not filed a Form C.
Where is it said that they have to file a hard copy of it? Where are you reading 79?
Page 79 is on the top. On the top, in the paragraph ending in the top, it is in the event of discrepancy between online and hard copy of technical bid, the online bid shall prevail and shall be considered for evaluation. So they have failed to submit the Form C, and it was taken the back door and submitted in hard copy. It was not in online bid. That is the admitted position.
Mr. Sharma, that refers to affidavits and undertaking.
No, these are-
No, not other. Affidavits and undertakings in original and other self-attested documents shall be submitted in the envelope containing the technical bid and clearly marked hard copy of technical bid. In the event of discrepancy between online and hard copy of the technical bid, the online bid shall prevail and shall be considered for evaluation.
My lord, at page 7,
They are
at 78, Madam, below the bidder shall submit both technical and financial bids to online. One hard copy of technical bid along with supporting documents. That is where it starts.
now you do one thing. Let them. How many years you are big? Like. How many prices are being improved? The renewal is only for purpose of gathering money. Unless, otherwise the license is not cancelled unless they get instruction. The license is virtual, perpetuity, unless it is cancelled or suspended. That's the law. So therefore,
That we are telling them. So because what has happened, what has happened is forms is mandatory in all of the districts because of
so then what that your form is not there. Why on earth do you have this architect business?
No, that is an oversight on my part.
That is the most.
But it has to be left.
That way, you know, the report.
No, we are fine.
Architect was also. Hello, yeah. When today dismiss. And after the vacation. That is the only worry. This in time order should not. Not by habit or same. Or tomorrow. If it is such a continuing problem. This same order has been going on for long. Anyway, you may also have the opportunity of both of you reading some. Both of them. The 45 minutes. Think we should know the command of the ground itself. Taking into account the paucity of time, this court directs this matter to be listed on 21st of July 2026. Final disposal and routine. Interim order passed earlier shall continue. Heard Mr. Ashrama, the learned senior counsel, appearing on behalf of the Excise Department. Mr. Esbota put the learned senior counsel appears on behalf of the respondent. 6. On account of paucity of time, the hearing could not be completed. This court also takes note of that since 8/4/2025, there is an interim order passed. And thereby, the retail outlet, the license for the retail outlet could not have been issued. The state petition to retail outlet. This would also, that if there is a delay, if there is a delay in disposal of the petition, the state, it affects the revenue of the state. In as much as without the retail outlet, the state will not be able to earn the revenue. Considering the above, this court directs the listing of the instant petition for final disposal on 21st of July 2027-26 at 2 p.m. for final disposal. Interim order passed. Right.
Consideration by the action filed by the Honorable Gauhati High Court. Really, it has not been complied with. Page 52.
What?
Page 52, my lord.
What is your case?
My lord, case is that, my lord, a mediation order was put on the children. Middle part under the second. There are two court actions.
So, have you filed the suit?
My lord, pursuant to that, my lord, the other side has filed, my lord, appeal before the deputy commissioner along with the coronation petition. File of the section 48. There is a delay of 150,000 something or
50,000?
15,000, 1.5. Because my lord, 76 order was put on the challenge in 2013, my lord. Therefore, my lord, what happened that we agitated this issue before the first appellate forum, while the matter was dealt with on the section 47. That order containing, my lord, take the 63.
What is this paying? We are concerned with paying.
Yes, my lord. The
Taking the suit to
My
the
lord,
appeal, your appeal.
yes, my lord.
Then why did you dismiss?
My lord,
You have challenged what appeal?
my lord, on May it was dismissed, but the condonation part has not been dealt with by the post court. That is my grievance.
You have purchased it by e-auction.
Yes.
You file a suit.
But after auction, it was challenged by other side. Their rights, their basic claim is that they are the owner, but they are no document is some anyway, my lord. After all, they have filed a member, they have challenged the petition owner. But in between, they also impose this honorable. This honorable court find order is 5/9/2020, 2009 to pass a 2/4 act. First, they have to file an application by way of appeal under section 47, followed by section 148, condonation petition. Now, once the condonation petition will file, that in the light of section 148, subsection 3, the matter has to be dealt with by the additional deputy commissioner. Now, additional deputy commissioner, my lord, there is no single whisper about the condonation part, and pass an order, my lord, out of which, my lord,
I understand, Mr. Thomas. In fact, it means that you are in whose land it is?
my lord, I am the auction partner.
Who is occupation?
My occupation. They are disputing, no doubt. They say,
Then why you are not filing a suit?
my lord, the suit is there, my lord, no doubt we are going to file.
I think we dispute.
But my lord, kindly see.
Once you dispute it, then the suit also go.
Only one aspect is very important.
No, this is a question that you are claiming title in the report.
Yes, madam.
You are claiming title, he is claiming title.
Yes, sir.
So both of you are claiming title before that. No, I'm therefore saying, both of you will let both of you go to the civil court.
No problem.
And with an observation that these observations which are being passed by the revenue court shall be bound by shall always be binding upon any directions of the civil court will bind out the revenue court direction. Now you are not going to pay mutation is in his name.
Right now, my lord, it has been kept against my lord because of the direction passed by the Supreme Court. Earlier it was substituted, my lord. My name was deleted.
And let it be very good. No rights shall accrue on the basis of.
Yes, my lord. Only one aspect, my lord. We will go to the civil court no problem, my lord, claiming our rights title, both parties will be my lord there. But Lordship clearly that observation required that this order of the revenue court will not affect, my lord.
That is what I am saying.
Yes.
What am I saying?
Yes.
It is a dispute between you and him.
But
he claims to be the owner and you claim to be the owner. So therefore the parties are relegated to go before the Supreme Court. They will fight, claim, title.
then there is the situation
on the land. And the directions so passed by the civil court will always be binding upon the revenue court. Because the revenue court basis cannot be the decision.
Absolutely. I think has to be there.
Or Mr. Estamar is the council. It's going to appear that we have one number two. Revenue is there. You see, anybody for this is there?
Yes, my lord.
You see, anybody?
That will number one.
Kindly give your name. The present petition has been filed challenging the order dated 15/5/2025 passed by the learned Assam Board of Revenue in exercise of the powers under section 147A of the Assam Land and Revenue Regulation 1886. From a perusal of the impugned order, it is apparent that while the petitioner is claiming right over the land on the basis of having purchased the land by way of an auction sale held on 8/12/1976. Bracket auction sale case number 702/477/1975-76, followed by mutation granted on 12/4/1979. The respondent, on the other hand, claims that the land, respondent number 2 claims that the land belongs to what originally belonged to his father, who was a recorded pattada of 1 bighah of land under tag number 124 and by virtue of Sita mutation granted on 14/5/1971. It is the further case of the petitioner, respondent number 2, that they are in continuous possession and have been paying the land revenue. It is well settled that the revenue court's jurisdiction is limited only to decide as to from whom the revenue is to be collected. The revenue courts do not have the authority or jurisdiction to decide the title over the property in question. Under such circumstances, in view of clear, under such circumstances, it is the opinion of this court that as the petitioner on one hand, as well as the respondent number 2 on the other hand, are claiming the individual title over the land in question. So, such title has to be proved before the civil court by filing an appropriate suit for declaration with consequential reliefs. Mr. Esamaria, the learned counsel, appearing on behalf of the petitioner, submits that the petitioner would file a suit. Submits that the petitioner would like to file. Submits that in view of the actions on the part of the respondent number 2, the right title and interest of the petitioner have been clouded. And as such, the petitioner would like to prepare an appropriate suit seeking declaration of right title and interest, including consequential reliefs. Taking into account the above, it is the opinion of this court that this court also is of the view that it is also well settled that any decree passed by the civil court would always passed by the civil court on the basis of on the question title, right title and interest over a land is binding upon the revenue courts. In essence, it is therefore the opinion of this court that all orders which have been passed by the revenue courts shall be subject to any suit so filed by the parties before a competent court of civil jurisdiction.
Filing status could be maintained by the both parties.
What status quo?
What happened?
No.
Only one line, my lord, limitation ground. No, my lord, that has been already dealt.
I'm saying it.
Only one protection, my lord.
Mr. Samaria, don't come up and say what is going to happen.
My lord, thing is that they are already fighting, my lord.
Regarding
Already fighting, my lord.
For?
The land, my lord. There are some, my lord,
for possession.
Yes, my lord.
You are in possession, so you take an objection.
What happened, my lord? Till filing, my lord. Nothing, my lord. Till filing, my lord. Till filing.
Another order I can pass that this court does not find any merit to and dismiss the. What is this, Mr. Das?
This is regarding, we are a society. We are a society.
Urgency, no urgency.
Actually, in this case, I mean, led by Mr. Gaines or I mean, led by Mr. Gaines or would have argued. Anyway, I'll.
Urgency, no urgency.
Yes, Lordship, I have.
Where disputes are there, my lord, the civil case is pending, everything is
No,
pending.
that is a
Or
different
that
aspect.
He's taking time on account of.
No, I am not taking time.
Lordship, only see one line, my lord.
Lordship,
Only one line.
Lordship, may I just present the
Basically, see the prayer part, my lord.
Lordship, here the Canara Bank was operated by the erstwhile members of the society. the society members were changed. There was an interim order in the, in a civil suit. There's an order in the criminal case, and we had written to the Canara Bank also that we may be allowed to operate the bank. They are deposits more than 10 lakhs in the bank, and we are the persons who are operating the bank, and the income tax notices are being received by us. That is the difficulty. Lordship, I can show.
My question is there any urgency?
Lordship, yes, there is an urgency. It can be immediately after vacation. Lordship. Immediately after vacation.
Taking into account that the pleadings that complete, list this matter on 15th of September 2000.
Lordship, 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 the bank, that, Lordship, I earlier date, Lordship.
After 3 months. Okay, now let me. Why? 22/2026, at the request of the learned counsel for the petitioner matter stand adjourned to 13/3. 13/3, at the request of the learned counsel for the party, the matter stand adjourned to 23. 23, on the prayer of Mr. R.J. Das, appearing on here matter to be lifted after 2 weeks. Now, after this, if I am fixing a matter on a Tuesday, and you are saying that you have a problem,
Lordship, September, let me at least July or August. Lordship. July, at least, Lordship. I pray that much because my bank, because I've been.
argue the matter. I'm thinking I'm not argue.
Lordship, I try to interpret because
Otherwise, take the dismissal.
because Lordship, may you please to here we had just of the here of the petitioners hearing, they were a society in 2018.
These people are having the signature.
Yes, Lordship, the account of payment. That is because they, by virtue of being the members of the society. The society membership, there was a dispute, there was a change. Now we filed a civil suit. Injunction order was checked, then we filed a CRP. CRP in the CRP order is annex. Here it is said that we will be allowed to operate as the exact line will be part of the society. Thereafter, there was even a criminal case where it was clearly said that we are the persons who are in control of the society.
Is the criminal courts having the jurisdiction?
Lordship, I'm saying court has
Where
given.
the suit filed?
Lordship may come to page 31. Property part is 33.
31.
31.
The judgment. Then where's the order?
Lordship, 31 is the CRP. Suit is pending.
Where's the copy of the claim?
Lordship, I have annexed the order.
Order would not go. You don't. No, these are disputed questions of fact.
Lordship, that part has been. No, Lordship.
Go the trial court.
No, Lordship, here I am not
No,
saying anything. No,
Why
I'm not
should I-
saying.
Why? See, this is the dispute between 5, 6, 7, and 8 with the petitioner numbers 1, 2, and 3. You are entangling Mr. M. Sharma unnecessarily. Isn't it? See,
No, Lordship may give me just 5 minutes to impress on. Lordship, here, why?
5 minutes is over. I think the judgment is done and dusted. 425.
Lordship, here, the bank account that has been operated. I'm the one.
So first of all, whether you are entitled to operate the bank account or they are operated, this is absolutely a civil dispute. This is no public law limit involved.
Lordship, to that, may I respond, Lordship? Now a bank, when the bank account is operated,
The bank account, the bank will be bound by what? The KYC, the know your customer. Now, who is the customer? Now, that the bank has to look into it. If the bank has to look into who is the customer, that means who
We
is,
cannot, no, because you say, I would have understood. Your only case is that you should be allowed. No. You say that don't allow them.
no
They
lordship,
have also a claim.
no lordship, because here lordship may look into, I have annexed the documents where there are deposits for more than
I am
10
not
lakhs.
so prove it.
More than 10 lakhs, there are documents of
When we have this election, people still now not filed. Once it is there, I am giving a tribunal case, then you can, otherwise here, no case.
lordship, lordship, the bank account, there are deposits.
201, my lord, page 201. On that, order was rejected now, my lord, the second attempt is by way of.
No, it's not rejected.
Let us see the injunction order.
Where it is, 33 is the injunction order, the CRP.
Never CRP.
No, that is against the rejection of the injunction order. That's where we.
201, huh? Where's the page? Huh? 201.
Lordship, it's 242, actually, the numbering is. Against this order, we had come in CRP.
Now, where's the first injunction order?
First injunction order is 242.
Huh, did you miss appeal order? Or first injunction order? There is an appeal order. Where's the trial court order? Injunction order. Okay, the pleadings are, from the materials of report, it seems that there are civil proceedings pending between the petitioners as well as the private respondents. Certain orders have been enclosed, but without the pleadings of the civil courts, nothing can be decided in the instant proceedings. Accordingly, either of the parties are granted the liberty to perform the court by way of affidavit the pleadings, unless and until such pleadings are filed, I understand that John Sinai die.
Lordship, the word Sarada may not be issued. I'll file. Neatly okay.
First time, second time. What is the matter?
Out of 17 level. My lord, covered by Jaku number, my lord, 176, 116 of Patta number 122, on 5. Subsequently, my lord, the petitioner name was indicated, my lord, in the year, my lord, come to this 19.
Who has passed this order? Who is the respondent number 3?
Respondent number 3 is a circle of sign.
Why you are not filing any appeal?
My lord, we have filed appeal, my lord.
Where?
First appeal filed, my lord.
Where is the order?
It's not district court.
Where is the order?
My lord,
No, have you not enclosed?
no, my lord, subsequently passed.
Then what happened?
That appeal was first listed on the lord, 3rd of January 2026, my lord. Thereafter,
What happened to the appeal?
the respondent, private respondent has not appeared before the,
What happened to the appeal?
not yet disposed of, my lord, pending.
Would you show me the narrative that appeal of the body to dispose of the appeal? You are the private respondent. You appeal with it. No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
appeal to the escape appeal to it's this one. The present petition has been filed by the petitioner challenging the order dated 8/3/2010 passed by the Circle Officer cum Assistant Settlement Officer Bilasipura Revenue Circle. Whereby land measuring 3 acres, 1 kata, 3 acres covered by DAS number 116/276, Pata number 112, 122 of 115 new of village, Pata, Part 1 under Bilasipura Revenue Circle was mutated in favor of the respondent number 6. It has been brought to the attention of this court that in the meanwhile, during the pendency of the instant petition, an appeal has been filed before the office of the district commissioner, Hubri, and the said case number is RCCMS oblique RAD oblique BIL oblique 2025 oblique 12 oblique 01309. Taking into account that the appellate authority is presently dealing with the said appeal, it would not be proper on the part of this court to exercise its extraordinary jurisdiction. Accordingly, as both the parties, that is the petitioner as well as the respondent number 6, are present before this court, they are directed to appear before the additional district commissioner, Hubri, in connection with reference court case number, on 27/2026 for further proceedings of the appeal. In view of the above, the petition stands closed. Without question, stands closed. It is observed that this court have not decided on the merits, have not decided anything on the order dated 8/3/2010, which is the subject matter of appeal before the appellate authority. And the appellate authority shall duly consider the same in accordance with law.
That one more thing, my lord, there is another order, my lord, passed on 21/8/2025. Subsequently, after filing the rate, thereafter we have preferred the appeal. That is on record, my lord, page 62.
What order?
My lord, after, my lord.
No, but we have not challenged that order in your.
No, this order might have during pendency of the.
But we have challenged both, no?
Yes.
Okay. But it is in respect to the same land.
Yes. Not same land, also higher purchase different than is.
Okay.
My land is, my matter is different, better. Public. But that prescribed time, of the update.
It is further observed and directed that upon clearance of both the parties, the additional district commission would be shall decide the same appeal as expeditiously as possible and preferably within a period of 6 months from the date of appearance of both the parties. That is, and preferably within 6 months from 27/2026, the date so directed
for appearance of both the parties before the additional district commissioner.
That was this in our affidavit. That was this, that our affidavit, that should be for an appeal of the High Court against the order of pending matrix and dispute at the time and date. Without pending the appeal, they have been participated. That is why I was done. Right.
Weeks time of already. Demand has been processed also. Or payment. Mr. Anand Das, the learning counsel appearing on behalf of the Water Resource Department submits that the demand have already been processed for the purpose of payment of the due compensation to the petitioner. First, taking into account the above list this matter on 9th of September 2026. In the meantime, appropriate steps be taken for release of the compensation amount if the demand could be processed. Else, an update be provided.
What is it? Regarding ex-gratia of women, my father was killed in extremist violence. And there was some communication also I had given wherein proposal must be sent by the circle officer.
Yes, you have not been able to pay because in spite of communication, you have not submitted the Aadhaar card, PAN card for according to regional sanction.
This is told today, I mean, I connect the office, but this is okay.
But Mr. Cohen to the council appearing on behalf of the petitioner hearing has approached this court on account of for claiming the additional ex gratia payment of rupees 2 lakhs, which have not been paid to the petitioner. This involvement, the learned Gundavandan advocate have placed before this court an instruction dated 16/6/2026, wherein it is seen that due verification has been conducted to the effect that the petitioner is otherwise entitled to the amount of explicit amount of rupees 2 lakhs. However, in spite of various communications, the petitioner has not submitted the next of kin certificate. Will be. Only the bank account details and relevant documents of all the eligible next of kin for processing the proposal for release of the additional ex gratia. The same instruction is kept on record and marked in the letterhead. Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits to the petitioner that submit the said documents within 2 weeks to the additional district commissioner, Pharmacy or DMA Hojai. It is on order that upon submission of the state documents, the necessary steps be taken for the purpose of disbursement. It is ordered that upon submission of the documents by the petitioner and upon being satisfied as regards the documents, few steps be taken for the purpose of disbursement of the amount of the ex gratia of rupees 2 lakhs to the legal representatives of late Samsuddin Ahmed, who was abducted on 12/10/1990 by the members of Alpha. So this matter again on 14th of September 2026 for an update. So Sina, what is the?
This is a matter wherein the pension amount of this petitioner was siphoned from the account by the fraudster. And I categorically stated that when he went to take out the money from the ATM, the card got blocked there and it didn't came out. Thereafter, we rang in the helpline number which was pasted out there. Where we filed affidavits. Affidavits have been exchanged here, actually. Affidavits have been. Now they have came up and said that I have withdrawn the money from on four occasions from the IDBI ATM as well as purchased the wine from the wine shop. Now that statement has been made without any inquiry or without seizing any CCTV footage. Now there was an FIR lodged before the police station, and on the last occasion the police say no, the bank says. Don't the bank and the police station they come up and say how they are saying the wine shop because the ATM of the wine. Yes, yes. Yes, yes.
And the ATM they are saying, but whether you have gone or not. Anyway, we have it.
But the English report says one thing that the money was siphoned.
And commissioner paid. Municipal.
Yes, sir. This is mentioned.
It is the opinion of the matter requires accordingly this matter on the 3rd of July 2026. On which date attempt shall be made to dispose of the petition. Liberty given to the council for parties to mention the matter of the.
I'm deeply aware. What your lordship can do, it's not inconvenient. That's for your lordship. I'm deeply. Yes, sir. Grateful. Your lordship.
Yeah.
Paging or paying it.
Be very serious.
Also, take this about matter of not 12 and 14.
Pay. We have mentioned, we make everybody a party. Okay, okay, we have it. Keep it all fine, huh?
Yes.
It's the matter of all the power.
We did take this. Right? We did take this.
27. You want to do it during the vacation day? Withdraw. The people there will plan for the feeling. What is it? One day. Jobless elephant catcher community. Huh? That is elephant, what you do? Oh, you are elephant catchers. Now you want rehabilitation.
They become double.
You have not filed affidavit.
Receive instructions that
Data needs to be forwarded by the deputy commission, union environment, because that fund is, will be coming from union environment.
Understood, why you are bringing the deputy commissioner out there?
That is what.
They are Hakifandi out there, they are looking for it.
We will file affidavit.
You do one thing, you and the deputy commissioner, both of them file an affidavit, taking into consideration what is the. Then only we can take it. Who appeals for the deputy commissioner? Taking into account the issue involved, this court directs the divisional forest officer where? Division forest officer? Where do they reside?
PCCF is a party here.
Direct the PC.
Or yes, any delegated office by.
No, we direct somebody important.
PCCF, wildlife thing. PCCF, wildlife.
We direct the PCF wildlife as well as the DC. What?
Could be one because it involves multiple districts. So better one department. Revenue and disaster
Management as well as the PR additional chief secretary. Revenue and disaster management department of the government of Assam to file affidavit as to whether the petitioners were in who were earlier engaged in funding and such other activities would be entitled to any form of rehabilitation, and if so, how such rehabilitation can be provided. This matter again on 12th of August 2026. The same authorities shall be.
The matter is related to the question that petitioner was elected as council person member. He has been reviewed by the deputy commissioner on the ground that he was involved in Sundays. You must cited this one. That we have
Got to stay. No stake. This. You are referring to Aisha Khatu.
Yes.
And there are other judgments of Dosi. Aisha Khatu has been approved by the division.
My lord, it's pending. Both pending. One disposed of, my lord. That is not directly Aisha, but it will. Yes. What to other matters also there, my lord. The local pending right now. Yes, one disposed of, my lord. That was in. Yes. Yes, yes. Yes, yes.
We finished our entire investigation. Dismiss or allow?
Yes.
People are aware. You always come at the last moment every day. The matters are always late. You antagonize the race. And huh? Ah. Yes, tell me.
Aligned with the summary rejection of the tender at page 126. My first ground is that after 2 days of my rejection, I filed a representation. As per the clauses of the tender, they had to consider it within 7 days and move forward. But they did not do that. Thereafter, they settled it with the private respondent after the bid validity is over. Now,
And that is okay. They may have extended the bid validity.
that is one.
That is their prejudice.
Yes, Lordship, but Lordship, that can only be done with the consent of the bidder. That consent is not taken in the affidavit also. There is no mention.
Understood, but Mr. Bora, that cannot be a ground because if he has no objection of he may very well say that without my objection, they have given you my bid validity period was over. If the private respondent did not say, how can you say that? Well, no problem. Your contention is the private respondent has been granted the contract beyond the bid validity period.
Yes, sir.
And they have the FCI have not taken the consent of the private respondent. Isn't it your case?
Yes, Lordship, in the affidavit, the clause it has at page 29, which says that,
Now, who are you to raise this issue?
Lordship, one of the bidder.
No. How can you be concerned with the private respondent?
And
Private respondent may tomorrow say that look here, whatever may be, I have my bid validity is for 180 days. I am not going to extend it beyond, and you cannot impose upon. I mean, very well said. Who are you?
And secondly, sir,
Unless you are holding the bid for the private.
secondly, Lordship, the summary rejection ground that I have given the work experience, but I have not given the award letter. That is the ground. Therefore, Lordship, in my presentation, I say that I have given everything as part of format. They had to, as part of clauses at page 66, they have to consider my representation and move forward.
You got a stay or not?
No, still.
What do you mean?
We are completely, but if any day after the beginning. But for a final.
Just so many final proposals have.
And otherwise.
You are appealing for private respondent. You have no objection with the bid validity, beyond bid validity, contract was granted. We don't have any objection.
Like we have taken a consent from only the bidder left out. After he was technically disqualified, man. That we have stated categorically in paragraph 16.
So that is immaterial. In fact, that is an immaterial.
Since he has raised the query.
Only the question is whether he had submitted the documents in support of his credential. That's the only issue.
That
Today we don't have the time. Otherwise, it was around 4:15. I would have done it. I didn't think we have it. This matter again on, well, taking into account that there is no stay order. There is no intent directions passed in the instant proceeding. This matter on 22nd of July 2026 at 2 p.m. and an attempt shall be made to dispose of the.
Public.
What is this?
Still does not move better.
It could not be provided. Instruction is awaited, madam. Why it could not be provided?
So why you are not doing it under the Right to Information Act?
This is for a suit.
My lord.
So why you are not bringing the Right to Information Act? Why do you have to file a petition for this? Isn't the Venn diagram map available on the Right to Information Act? Collector. Please apply or the why do you need the Venn diagram the time on? Because it will be a very big one. Understood. What is your school? These are all dark numbers given out there. Why do you need a Venn diagram?
I case, I am Macmillan defendant in that.
Then why you are not following it from that court? Why are you here when the suit is pending? Do you think this court is exercising a jurisdiction on the order 7 rule 14 or order 11 rule 14? You have reduced the High Court to order 11 rule 14 proceedings. Absolutely no. Hey, Rita, you are disposing, you are dismissing his petition. Right away. Why on earth should do this court? You can very well file an application there. No. Before that court. You can very well issue the file an application under order 13 rule 10. You can file an application under order 11 or order 13 rule 10 before the court, wherein the matter is pending, that kindly call for the Venn diagram and take that report. I'm not going to pass this order. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Ms. P.R. Mohanto, the learned counsel appears on behalf of the respondent numbers 1, 2, and 3. Mr. So-and-so appears for the respondent number 4, 5, and 6. The petitioner herein has sought for a direction upon the respondents for providing the petitioner a certified copy of the required Venn diagram map for the year to 1961-62, along with the latest on in respect to village Chakrisar under South Salmara Revenue Circle in the district of Dhubri. This court duly inquired as to why the petitioner seeks such an application. Seeks the copy of the Venn diagram map. The learned counsel submitted that the same is required in connection with title suit number 218/2025. So that the petitioner would be in a position to prove his case. It is very pertinent to observe that the writ court is not a court wherein the jurisdiction can be exercised in such a manner that too when the petitioner can very well file appropriate applications before the civil court. For calling for the Venn Dyke map, and the civil court duly has the jurisdiction to consider the necessity of the said evidence and thereupon pass appropriate directions. Under such circumstances, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed with cost quantified at rupees 25,000. The said cost amount shall be realized by the receipt with Deputy Commissioner Deputy Commissioner Dhubri through the Bakizai officer from the petitioner as areas of land revenue. Next time don't come up with these type of things. You have considered, you have rendered the 226 code into nothing. My goodness.
Special witness also he can prove.
Yeah, he can call for the official witness. This is not done. Please seriously. Of course not. What happened?
The loss is passed through order, my lord, on 22/4/25. Consider restored.
They've not.
And now they have passed an order whereby, my lord, they have revoked that order. By same order, my lord, they have debarred, product department order.
It's a different case.
My lord,
Product department is different from
no,
product.
how they can, my lord, don't, my lord, debar that.
It's a different cause of action.
Hello?
That's a different cause of action. It's a different cause of action, don't you think so? If there are more than 3 product departments, then they may go for a firm department. My basic case out here in that judgment is that you cannot go for firm department without there being product department.
Now, the farm department between cancel.
So therefore nothing remains. However, liberty is given to you to file. If you challenge this, you challenge it. I can't pick it up on this. Or Mr. T.S. Sahavala, the learned counsel, appearing on behalf of the petition, assisted by Swen. Mr. D.P. Gora appears on behalf of the respondent. The petitioner have said the order dated 14/11/2025 passed by the managing director, na?
Yes.
Passed by the managing director of the Assam Medical Service Corporation Limited, whereby the petitioner was debarred. Petitioner's firm or what? The
Company.
The petitioner company was debarred, oblique blacklisted. So this court passed a detailed order on 22/4/2026 and subsequently on 22/5/2026, thereby directing the respondent authorities to duly consider the case of the petitioner in terms with the judgment passed by this court in the case of Nestor Pharmaceuticals Limited and another versus State of Assam and others, reported in 2025, SCC 9 BAU 5168. It is seen that in pursuance thereto, the impugned firm debarment notice number 582884/200068 dated 14/11/2025, 14/11/2025 have been withdrawn by an order dated
9/6.
9/6/2026. The said order is kept on record and marked with the letter X. Under such circumstances, nothing further remains to be decided in the instant proceeding. It is observed that if the petitioner is aggrieved by the productive environment by the said order, which is kept on record and marked with letter X, the petitioner would be entitled to would be at liberty to avail remedies in accordance with it. Yes. My matter has been listed as the last item. Last item.
Yes, one more.
You must have got it done.
Is seeking. My lord.
Yes,
Requesting
wait
for
for
full
this by extension of time from one of the items. What is the whether?
My lord, one affidavit has been filed, my lord.
Why do you need so much of time?
We are examining, madam. That is immediately after vacation, option will pick them.
Mr. So-and-so, the learned, Mr. S. Dotto, the learned standing counsel of the PNRD department submits that the petition, that some more time is required by the commissioner, PNRD, to place a report in consonance with the order passed by this court dated 25/2026. He therefore submits that 4 weeks' time may be granted. 4 or 3? 4. You write numerical 4 and inside 3. Why?
Well, that was a mistake, madam.
Which one? You 4. 4 weeks' time for filing, for bringing on record the said report. List this matter on 27th of July 2026. The Commissioner PNRD shall take all necessary steps so that no further adjournments are taken on the next day. And bring on record the same. 26 is Sunday. 29th.
We need some time to file. Time to file. They are filing 23 numbers of work orders there. They are in this petition. They are about 23 numbers of work orders. So we need some time to collect.
What is he asking for?
They are asking for not to blacklist them. We have not even issued a notice. And another is
Asking for payment of
outstanding bills. They are asking.
allow the petitioner to participate in future. IOCL authority particularly spoken not to blacklist.
That we have
Commission happen in peculiar time. Hey, this type of is not permissible, huh? You're asking so many things. Too much. When are you filing your affidavit? You file after 2 years. Don't file it. This type of petition asking all the tender is no mentioning properly. One is a case that don't blacklist. One is a case of pertaining to non-payment of due. How all these things are being done together? So
it's a sole proprietorship.
understood. I understand that the proprietor has gone missing. Now the son and proprietor has to do it. Not that. Okay. The council appearing on behalf of the IOCL submits that some more time is required for filing the affidavit in opposition. So accordingly, list this matter on this court also inquired with the learned standing counsel of the IOCL as to whether there is any contemplation of taking steps for blacklisting the petitioner. That is already there.
Yeah, already.
taking into account the above, list this matter on 14th of September 2026. In the meantime, the IOCL shall bring on record the stand by filing down.